Okay, good afternoon, everyone, and thank you very much for joining us this afternoon. We're very thrilled to be in your company for the next few hours, and we hope you find the following sessions both informative and engaging. Just some housekeeping rules before we start. Attendees do not have access to their mic function, so please, if you have any questions, please type them into the provided box, the chat box, and as much as possible, we'll try to accommodate any questions. To kick us off this afternoon, I'd like to welcome Mr. Ngomartins Okuma, the Executive Director of Africa Construction Law, to give his welcome address. Over to you, Ngomartins.
Thank you very much, Ademola, and good afternoon, everyone. Welcome, everyone, to the inaugural launch of Africa Construction Law. My name is Ngomartins Okuma. I'm the Executive Director of Africa Construction Law and a Senior Associate in the leading law firm of Aluko and Oyebode, Lagos, Nigeria. As you may well know, Africa Construction Law is a Pan-African initiative set up by construction law practitioners across Africa and in diaspora to promote thought leadership in the field of construction law and practice in Africa. ACL, as it's popularly called, has an advisory board made up of experienced and distinguished professionals in the field of construction law. Indeed, we are very grateful to have Angus as one of our advisory board members, and Pamela, who has been very supportive to ACL and its objectives. ACL is managed by a global steering committee made up of construction law practitioners and other professionals working in leading law firms and consultancies in Africa, London, and the United Arab Emirates. As of today, ACL has country coordinators in 20+ African countries, including key African jurisdictions such as Nigeria, Kenya, South Africa, Egypt, and Morocco, to mention but a few. Our country coordinators are supported by sub-regional coordinators and a board of directors. As ACL is set to launch today, people may be asking the question, why is it important to have a construction law-focused initiative for Africa? The answer lies in the steady rise of infrastructure projects in Africa, which has been driven firstly by the increase in direct foreign investment in the continent. Secondly, African governments have prioritized the development of infrastructure projects in a bid to achieve regional integration triggered by the commencement of the Africa Continental Free Trade Area Agreement. Consequently, and indeed going forward, the demand for construction law expertise is likely only to increase. Unfortunately, with the number of infrastructure projects rising within the continent, so too with the frequency of construction and engineering disputes. Regrettably, African arbitration practitioners have been sidelined in international arbitration, including construction disputes. For instance, the recent ICC statistics shows that despite African countries representing 7.5% of total parties involved in ICC arbitration cases filed in 2019, only 3.6% of the arbitrators appointed originated from Africa. This is a stark contrast to North and Western Europe, with 56.4% of arbitration appointments. This trend is equally true for participation as arbitration counsel in international construction disputes. One of ACL's aims is to provide support to African practitioners so that more effective participation in international arbitration, and more particularly, arbitration involving African parties, is achieved. To achieve this objective, ACL would encourage construction law expertise through capacity building and training. In the coming years ahead, we hope to embark on the following. Number one, engage and share ACL platform with young professionals seeking areas of law to specialize in. Secondly, promote all forms of ADR to encourage and support the development of ADR support services, such as claims, delay, quantum, architectural and engineering expert witness work in Africa. Thirdly, contribute to the development of practitioners in Africa with construction law experience by providing a devoted forum for specific construction law training, engagement, and networking. Finally, to showcase those construction law practitioners within the continent that hold a wealth of construction law experience and share such experience through ACL. In doing so, it is hoped that the pool from which African arbitrators can be shortlisted for arbitration appointments will be expanded and diversified. At the core of each of these objectives is ACL's mission to provide thought leadership in the field of construction law by contributing to the development of the law, policy, and practices, including the use of dispute avoidance and resolution within the construction industry in Africa. ACL has achieved Pan-African coordination and cooperation among construction law practitioners across the continent and is currently working collaboratively with law firms, chambers, consultancies, employers, contractors, and government authorities. ACL seeks to engage in research at regional level and collect data relevant to construction law and practice in Africa. In doing so, it is hoped that it will be understood that construction law and practice across the African continent is not and ought not to be broad brush in its application. Rather, there is much to be gained from insights shared by experienced practitioners from different African regions and indeed the countries. If you would like to be part of ACL's initiative, we encourage you to reach out and join ACL through its membership portal on ACL's website. You are eligible if you are interested or professionally involved in construction law. Our members come from all sectors of the construction industry, including lawyers, architects, engineers, surveyors, contractors, developers, arbitrators, and experts. Therefore, on behalf of the advisory board and board of directors of ACL, I would like to thank all our collaborating and supporting institutions whose support, without which we would not have had this launch today. I would also like to extend my personal thanks to all our advisory board members and our incredible board of directors who have worked tirelessly in the past few months in ensuring that this event is a success. I'm also grateful to all our sub-regional coordinators and country coordinators who supported ACL initiative from day one and have worked tirelessly in ensuring the success of this event at the sub-regional level. Please enjoy the rest of the conference and thank you very much.
Thank you so much, Ngo Martins, for your opening speech. Our next speaker is someone I like and respect a lot for many reasons, one of which is the fact that he thinks and acts like an African. I would like to introduce Mr. Andrew Skipper, the head of the Africa practice at Organ Lovells, to give his opening remarks. Over to you, Andrew.
Ademola, you're very kind, and thanks very much for that brief introduction. So, ladies and gentlemen, good afternoon. I'd like to add to the opening comments of my esteemed West African colleague Ngo Martins on the occasion of the East Africa element of the Africa Construction Law Week. I'm Andrew Skipper. As Ademola says, I head up the Africa practice at Hogan Lovells, and I'm also co-chair of the UK government's Africa Investors Group, which is committed to building trade between the UK and Africa. We at Hogan Lovells build our practice in Africa on the 4 pillars of understanding, investment, operation, and respect. All 4 are apparent in the event we have today and the organization you're talking about. It's trite but true to repeat the fact that Africa has an infrastructure gap of more than $100 billion a year at the moment. If Africa is to thrive after COVID, and with the help of the Africa Continental Free Trade Agreement we've already heard about, it needs that gap to be filled, and this means investment. Investment will not, however, happen in an uncertain vacuum, and people will only invest if there's certainty of regulation and rule of law. That's why good law implemented fairly and with certainty locally and on an international basis in collaboration has to underpin the future of construction and law in Africa. And that's why this event is so important, as it demonstrates the critical role of respect and partnership between law and law firms on and off the continent. And I'm delighted to see that there are so many of our friends here today, including from Oraro, who are coming up next. So great to hand it back to you, Ademola, and enjoy your time here. Have fun.
Thank you so much, Andrew. Our next speaker is a leading lawyer, not only in the legal industry in Kenya, but also in Africa. I would like to introduce Ms. Aga, a senior partner at Oraro and Company Advocates, to give opening remarks. Over to you, Pamela.
Thank you. Good afternoon, ladies and gentlemen. My name is Pamela Gere, as you've been told. I'm a partner in the law firm of Oraro and Company Advocates in Nairobi, Kenya. Our managing partner, Mr. Chacha Odera, was to do the opening remarks, but due to unavoidable circumstances, has asked me to participate on his behalf. So I will represent him in this forum. The construction industry in Kenya, as is the case globally, is an important contributor and determinant of socio-economic development. According to the Kenya National Bureau of Statistics, the construction industry's growth in 2019 was at 6.4% compared to a 6.9% growth in 2018. In 2019, Kenya's construction industry contributed 7% to the GDP, making it a significant sector in the country. With regard to creation of employment, a survey conducted by the National Construction Authority indicates that in 2014, the industry employed 511,676 workers as skilled, semi-skilled, and unskilled artisans. The Kenyan government, as in most developing countries, accounts for most construction projects in the country with 60%, owing to the fact that a large number of the construction projects are infrastructural development projects. Other significant activities include general construction, being residential, commercial, and industrial, which generally account for the other half of activities in the construction industry. The National Construction Authority, which is tasked with the registration of contractors in Kenya, noted that 50% of the 18,000 contractors in its register of contractors as at 2015 were local contractors. It is, however, important to note that half of the market is dominated by foreign contractors. In Kenya's draft construction industry policy of 2018, it is noted that over 80% of Kenyan contractors are SMEs, which only qualifies them for smaller construction projects. Most local contractors lack the financing, manpower, and equipment to take up mechanical engineering projects, which creates a gap for the qualifying foreign contractors to take. A key contributor to the growth of the construction industry is the manufacturing sector, which is required to meet the demand for construction material in the country. The materials manufactured locally include cement, glass, steel, plastic, and ceramic ware. With regard to foreign investment, Kenya is a party to several bilateral investment treaties, some of which are not yet in force. The bilateral investment treaties in force currently are with Japan, the United Arab Emirates, Korea, Kuwait, Burundi, Finland, France, Switzerland, the United Kingdom, Germany, and finally the Netherlands. The construction industry in Kenya is regulated through various statutes, including the National Construction Authority Act, number 41 of 2011, and the Physical and Land Use Planning Act, number 13 of 2019. There are numerous parties who are involved in the construction industry in Kenya, either directly or indirectly. Some of these parties are not necessarily construction professionals. The professionals in the construction industry are governed by sector-specific legislation. For example, the Engineers Act of 2011, which provides for the accreditation, registration, and regulation of engineers, and the Architects and Quantity Surveyors Act, Cap 525, which governs the practice of architects and quantity surveyors. With regard to public contracts, the principal laws governing public procurement are the Public Procurement and Asset Disposal Act, number 33 of 2015, and the Public Procurement and Asset Disposals Regulation, which set out the procurement procedures that government agencies are to use. The Government Contracts Act Cap 25, which governs the making of contracts with government. The Public-Private Partnerships Act number 15 of 2013, which provides for the participation of the private sector in government infrastructure or development projects. And the Public Finance Management Act number 18 of 2012, which provides for the effective management of public finances where national and county government bodies are involved in procurement procedures. Some laws may not be directly geared to the construction industry, but they affect both the industry and its players. These include the Environment Management and Coordination Act, commonly referred to in Kenya as EMCA, which requires construction activities to be conducted in a manner that does not pose a risk to the environment, and the Occupational Safety and Health Act, commonly referred to in Kenya as OSHA, which requires contractors to ensure the safety of workers working on construction sites. Parties in the construction sphere should also be aware of the Public Procurement and Asset Disposal Amendment Bill, which is pretty new, number 20 of 2020, which seeks to amend various provisions of the Public Procurement and Asset Disposal Act, number 33 of 2015, which I spoke about earlier, and which amendments shall in turn affect procurement processes in the construction sector, and the draft National Building Regulations of 2020 to promote order and safety in construction works and health and safety of persons in or about construction works. Now, finally, how does COVID-19 affect the construction industry in Kenya so far? According to the International Labour Organization's sectoral brief on the impact of COVID-19 on the construction sector, the COVID-19 pandemic has devastated the world of work. Its impact, which varies across sectors, has been significant in the construction sector. As construction is sensitive to economic cycles, construction enterprises and workers are particularly vulnerable to the drastic decline in economic activities resulting from the pandemic. According to local reports, following the first reported case in the country in March 2020, the effects of COVID-19 on the construction industry have been, firstly, the negative impact on the supply chains, as most developers source for construction materials from nations such as China. This may translate to longer development periods owing to shortage of resources and ultimately reduced building completion. Secondly, the decline in project financing is also apparent, as some lenders are uneasy to finance construction projects owing to the current uncertainty in the economy, coupled with delayed project completion dates, making it difficult to obtain timely returns on their investment. Thirdly, the pandemic's direct impact in the real estate sector has seen the immediate reduction in the labor force as construction sites adhere to strict protocols and guidelines issued by the National Construction Authority. Fourth, there have been delays in obtaining permits and permissions from government agencies in a timely manner arising from the stringent government COVID-19 prevention measures. Finally, since the pandemic, many lawyers in Kenya are now rethinking crucial clauses in construction contracts to ensure that their clients are fully protected and are not exposed. Thank you for your time, ladies and gentlemen. We look forward to engaging and insightful discussions in this very timely conference. Thank you.
Thank you so much, Pamela, and our kind regards to Mr. Odera. We are privileged this afternoon to have the Chief Regional Procurement Officer of the Africa Development Bank, Mr. Otesh Tobias, give the keynote speech. He has very, very kindly sent in his pre-recorded keynote speech. Mansoor, I'm sure you have that. Could you just please put that up? Thank you very much.
Good morning. I'm happy to be here today because it marks the beginning of the Africa Construction Law Week. And I would also like to appreciate the organizers who put this event together, because I understand there's a lot of work that went into this. I'm also excited. I'm excited because this is the best time to talk about construction. It is the best time to talk about what is it that the construction can contribute in the infrastructure that will support the economic development of East Africa. But I also know that this conversation is happening at a time when we are experiencing the challenges that COVID-19 has placed before us. But I know that as East Africa, we are still standing strong. I know that despite the challenge that I'm going to talk about, we are still standing strong. And I know that construction industry has been affected in a number of areas because there's lack of capacity. You'd all agree with me that statistics, but even without statistics, if you just walk or pass some of these major projects that are happening in the region, you will see that they're mostly implemented by foreign contractors. And there's nothing wrong about that because we also want the best. But because our own contractors lack the capacity, lack the equipment, lack the experience and the technology that is required to implement some of these projects, it is an area that we are concerned about. I also understand that even if one had the knowledge, the experience, the technology, and the capacity, there's also an issue of financing and access to the necessary finances for our own contractors to participate in some of these construction projects. Generally, it costs about $250 million to construct a kilometer of tarmac road. It could be more. So if you're talking of more than 100 kilometers, how much capital is required? How much collateral? How much initial investment you require to be able to implement this kind of a project? It's quite a lot. And some of our contractors fall short. They are not able to provide the minimum that is required for them to access these projects. And this has been a challenge. So what do we need to do? I also know that there is inability, and I've been in the supply chain procurement industry for more than 30 years. And what I've seen is our tenderers or bidders from the region have the knowledge, some have the experience, some have everything that is required, but they lack the ability to submit a tender that is responsive, a tender that is technically compliant, a tender that would be able to compete in our local projects, but also even in the projects from overseas. Some contractors have been in the industry for more than 40 years, 50 years, but they are not able to package their document. They are not able to demonstrate that, yes, I can do this project, and this is the proof. That has been lacking. I've also seen that in some areas, there's reliance of China in some of our major projects. And we have seen through history that sovereign debt can be a problem, and it can affect the economy of the country in addressing some of socio-economic projects and areas within the country. And this is a concern even for East African countries. Now, let me say that despite these challenges, there are a lot of opportunities in East Africa that we can explore. And in particular for the construction industry to be able to access and to be able to address some of the challenges that I've just mentioned. For example, explore the joint venture or consortium agreements. It is also important that our contractors can take advantage of the local content that has been introduced in the procurement laws, procurement legislations of different countries. I'm reminded of a contractor in Ethiopia who really wanted to do this construction project, but he did not have the ability. And I encouraged him, why don't you form a joint venture? Look for someone who has the ability, get into a consortium and have them submit the tender, package everything, two of you can submit a tender and you'll execute. And they did that. And from then on, this contract now was taken to another level. And this is an option that our contractors in East Africa can also explore. East Africa has quite a good credibility when it comes to development partners. And we have a lot of them in the region, talking of IMF, World Bank, African Development Bank, and several others. I do also understand that these organizations have initiatives that are geared, that are directly linked to the construction industry because they are interested in developing the infrastructure. As an example, African Development Bank has 5 priorities. They call them High 5. And this is to feed Africa, to power Africa, to industrialize Africa, to integrate Africa, and to improve the quality of lives of people of Africa. You would agree with me that these projects would need a lot of infrastructure, which again would benefit the construction industry. It is therefore important to be looking out to get in touch with these development partners and see what is it that the players of the construction industry can do to benefit from some of the resources that are offered by these industries. And I do know that they're there. It is also important that we build the capacity of our own. Train our vendors and bidders on procurement. I know that if you visit the website of United Nations Business Development, there are more than 30,000 tenders at any particular time. And these tenders are not necessarily country specific. Anyone from anywhere can participate and win. It is also important that we start now looking at the vocational space. Because much as our education system is producing a lot of graduates, most of them end up working in restaurants, doing the jobs that are not really commensurate to the education that they have. Why don't you maybe look at a level a little bit down? Let us try and build and develop technicians. You'd agree with me that if you call a plumber in East Africa, or an electrician, or get someone to fix your car, the experience might not necessarily be very good. It is because we have not really built this industry to make sure that we get a kind of quality. And again, this is what is needed in the construction industry. Can we build technicians that can actually develop technicians that can implement some of these projects? And the beauty is it would allow us to win tenders locally and also even start with winning tenders abroad. I have a friend, his name is Ten from France. And when I visited him several years ago, he told me that he has 3 master's degrees. And he said some of the technicians who are working as plumbers and electricians make more money than him. It is really important that we also start looking at the technical field and develop our youth in that area. Let us also look at the private sector, which is an area that we can think of. For example, we need to explore public-private partnership because we have not really exploited that area in East Africa as much. Let us also look at the private banks and see how can they finance these projects at reasonable rates. Let us explore the need of reaching the mass, the low-income population, construct housing and accommodation. That would allow them to buy, but that would also allow the construction industry to make some money. I did attend an event which was organized by the Green Building Foundation. And there was a presentation that was made of a technology, a construction technology that would use locally available material like topsoil and sand. And you'd construct a wall without using mortar, without using cement. You just use the locally available material. I know there are several things that we can look at that is available locally. Let us also look at developing our youth, because there's a lot of energy there. And because unemployment among the youth is around 60%, between 50 to 60%, it is a labor that we can tap onto. We also have to establish our own financing mechanisms, or mechanisms that are not necessarily very expensive. And we have some good examples in East Africa. For example, the annuity road financing model that was adopted in Kenya. And we can use that knowledge and expand it into other areas. So as I finish, there are a lot of prospects in East Africa that we can think of. For example, we have the Ethiopia-Kenya electricity highway, which is worth $370 million. There's also an initiative, Africa Continental Free Trade Area, which will benefit African countries, but also East Africa. And there are big projects like the Uganda-Kampala Expressway, $229 million. The Nairobi-Mombasa Expressway, which will cost about $2.8 billion. So there are a lot of good prospects in the construction industry. But we can only access these if we build our capacity and if we make ourselves available and dare to try some of these projects. I know that the construction industry has a lot to play in ensuring that there is sufficient infrastructure in the region. But I'm happy that the African Construction Law Initiative is there and is engaging in this conversation that would allow our contractors to access these opportunities. I therefore look forward, as we continue with this conversation, to see a lot of ideas shared, developed, and used in the construction industry to take East Africa to the promised land. Thank you very much, and I wish you a successful week.
Thank you very much to Mr. Tobias for sending over such an insightful keynote speech. Our first panel discussion today will be on construction in East Africa and will be chaired by Angus Rankin, a partner at our Hogan Lovells London office. He will be joined by Suzanne Rattray of Rankin Engineering, Amin Musa of Anjawala and Kana, Paul Bayangir, construction claims specialist and a regional representative of the Institute of Construction Claims Practitioners, and Papayas Kazawadi, chairman at the World Federation of Engineering Organizations Committee on Anti-Corruption. Angus, over to you.
Thank you very much, Shivani, and thank you to all our guests for joining. I'm absolutely delighted to be hosting this panel discussion for at least three reasons. One is, as Shivani mentioned, my day job, so to speak, is a disputes lawyer, specializing in international arbitration with a construction flavor. But on this panel, I get to talk about some much more positive and big picture topics relating to the general outlook for the construction and engineering industries in the region. I'm also delighted by the eminence and the diversity of our panel, both geographically. I think we've got a fantastic coverage today, ranging from Zambia, Kenya, Uganda, and Rwanda. But also we've got a great diversity of opinion because Suzanne, Amin, Paul, Papias all have a different perspective on things, coming respectively from an engineering consulting background, a legal background, a claims consultant background, and so on. So I look forward to a really great free exchange of ideas to take things one step further after those incredibly inspiring keynote speeches. I will then just kick off with the first question, and thank you to those of you who gave us ideas for topics and questions that you find relevant. I'm not sure how much success I will have in trying to scan the Q&A and the chat box. If I have an opportunity to dip into there for a question, I'll certainly try to do so. But otherwise, I just intend to kick off with the list of questions I have here. And if my panel will forgive me, I've already earmarked some of these questions for particular people. And let's see how we go from here. Okay, so we've heard a lot about the bright prospects, challenges, but also very bright prospects for the construction sector in the East Africa region. And one guest has observed East Africa currently has the highest number of construction projects in the continent, recording 118 projects in 2020. That, if anything, seems low to me, but I wonder if that's 118, major projects or mega projects. Question to the panel: if construction is in good health in East Africa, as it seems to be, why do you think this is? And do you see this particularly East African momentum continuing? And could I ask perhaps Paul if he would be so kind as just to get us started? Paul.
Thank you, Angus. Well, for all the listeners and participants, I want us to appreciate that while we are experiencing a lot of construction in East Africa region, take it back to 2010, the region was facing a lot of infrastructure deficits. When you just compare the sectors of roads and power, look at 2010, Kenya, Uganda, Tanzania, Rwanda, Burundi, we're talking of only 22,000 kilometers of paved road. When you compare that with the South African region, actually the country around South Africa, way back in 2010, there were 606,000 kilometers of paved road. I mean, you're talking about 26 times more of road infrastructure. So the East African region had to attract all this kind of construction to try and bridge the gap between itself and what you're having in the region. Look at power. When you combine the entire East African region as of 2010, we're only producing 1,000 megawatts of power. Compare that with South Africa that had 9,012 megawatts of power.
Paul, I'm sorry to interrupt. I can follow the thread, but we're getting a bit of distortion. Just in case the problem is with our other guests, could I ask everyone else except Paul to go on mute if they aren't already? And let's just see if it improves. But we're following your answer so far, but I wonder if we could just do you a favor and hopefully cut down the noise for you. Should we try again with everyone else on mute? Thanks.
Thank you, Angus. Yes, so we're saying look at the power sector. As of 2010, the whole of East African region was producing 1,000 megawatts of power. So this calls for a very big investment in the power sector. It's unfortunate that the Ethiopia Grand Renaissance Dam is up for arbitration. We're looking at about 6,000 megawatts to come from that dam. So all these infrastructure deficits called for that high level of construction in the East African region. Now, the other second factor we could look at is that the East African community governments decided to do community projects. When you look at the Northern Corridor Transport Project, that is the road connecting all there from Mombasa through Uganda to Rwanda. These were being done as a community. So you now attract more investment and construction as compared to when you're doing the project as an individual country. We had the Common Border Post Construction Project in 2018, where the countries in the East African region wanted people doing trade to minimize delays and logistical issues at the border post, so that when you're moving logistics of goods from Mombasa, when you get to Uganda-Kenya border, Uganda-Rwanda border, it is a bit of a seamless process. So those were projects that were done communally. There's standard gauge railway is another community project that looks to link Uganda, Kenya, South Sudan, Rwanda. So all these count for the high volume of construction that we are experiencing in the region. Thank you so much.
Thank you very much, Paul. And to get another perspective on that question about the outlook and prospects for East Africa, could I ask Amin, if I may, just to give us his perspective from Kenya?
Sure, thanks for that. So I think over the last couple of years, we have seen a significant increase in project infrastructure development and therefore construction projects, not just in Kenya, but across the region. And I think there are probably 4 or 5 key driving factors that have seen that growth. Obviously, as part of this conversation, one of the issues to debate is, whether these existing driving factors will be relevant for the next few years or whether we will see a change in that. But in terms of looking back over the last 3 to 5 years, I think government policy, first thing, has been fundamental in East Africa. In Kenya specifically, the combination of Vision 2030 and the president's Big 4 agenda, which covers affordable housing and manufacturing as targeted areas, has certainly increased projects, infrastructure, and therefore construction. The government policy on renewable energy has led to a significant increase in project development. And in fact, as we speak, we're currently involved in 4 projects that have been under construction over the last 2 years and are coming to the point of commissioning. These 4 projects account for, several $100 million of investment in wind and solar renewable energy. So government policy has definitely played a role. Government spending, and this is going to be the interesting question about going forward, how this particular factor impacts construction and infrastructure. But government spending over the last 3 to 5 years, primarily, frankly, driven by debt, has had a huge impact on the development of infrastructure. So if you look at across East Africa, from Tanzania, Ethiopia, Kenya, the development of new roads, the standard gauge railway, the new airports that you see in Nairobi, Addis, Dar es Salaam, last mile transmission connection, by and large driven by government spending. And I guess the question is, going forward, will that be a driver? Will that continue to be a driver? I think the other remarkable thing we've seen over the last 3 to 5 years is the remarkable influx of new players in this industry. I remember several years ago when we were acting on the Lake Turkana wind power project, securing equity funding for an infrastructure project of that size was frankly problematic. And ultimately, to get to financial close, we required our contractor to take an equity stake, which we then offset against the EPC contract. We don't seem to have that issue anymore. When I think about the players that we are interacting with in this space, Actis, for example, over the last few years has been involved in the development of the Kipeto energy project, which is a 100 megawatt wind power project, in the development of Garden City and industrial parks. We have had Chinese state-owned enterprises like AVIC, Sinohydro, who are wearing both developer hats and contractor hats. AVIC is currently developing one of the largest real estate projects in East Africa at probably between $300 to $400 million in Nairobi. It's supposedly one of the largest Chinese equity investment in sub-Saharan Africa. We have seen a lot of Chinese debt funding and Chinese participation as contractors, but this is certainly a change where we're seeing Chinese contractors and state-owned enterprises now participating as developers and equity financiers in projects. We have seen an influx from India. We've got Sterling and Wilson that are currently building a solar project in Malindi. We have Shapoorji, which is an Indian conglomerate who is involved in construction projects in East Africa. They are providing equity funding for renewable housing projects, which we would have thought would be primarily driven by local investors. But you now have Actis, Shapoorji now getting involved in housing projects. We have seen the likes of Helios in their investment in Acorn, providing investment for university student housing. So we've had this massive influx of players on the debt side, on the equity side, on the contractor side, that has also helped to drive growth in sectors that we earlier thought were primarily locally driven sectors. And that has led to significant amount of money and technical expertise going into government housing, social housing, and a number of these other sectors that previously were primarily dominated by the local market. So there are a number of these factors that we've seen driving it. Obviously, the question as part of this panel session is, will these same drivers apply, or will we see different drivers applying to the construction industry?
Thanks very much, Amin. Amin and Paul, actually, that was these are very broad questions, so that was a masterly overview of much that is happening in the region. And I wonder if we might return to this topic, but I am interested when I look at the way that COVID-19 has really put under a spotlight the fragility of supply lines, whether that is in personnel, construction materials, moving around equipment, and so on. I just wonder whether that has interesting implications really for supply chains going forward as projects perhaps seek to diversify their risk, perhaps not have such long supply chains, tending to lead to China, tending to lead to a smaller number of global manufacturing sectors that are then quite easily thrown off if, God forbid, we find ourselves dealing with any sort of pandemic like that again in the near future. So if I could stay with you, Amin and Paul, for the next question. There'll be a degree of overlap with what I've just asked, but I think this is particularly focused at new entrants in the market. So I think some of our guests, we're happy to say, are tuning in precisely because they don't really have any significant track record in the region. And I think by new entrants in the market, you can take that to be entrants from whichever part of the contracting chain or wherever you wish. But what are some of the opportunities? And if I could add to that, what are some of the challenges for the uninitiated in this region? Why don't I start with Paul again for your answer? Paul, I think you're still on mute.
Thank you.
Yep.
Yeah. So for the new entrants, like I pointed out earlier, given our deficits, there's still so much to find in the oil and gas sector. Just yesterday, Uganda and Tanzania signed the oil pipeline project. Now, we're talking about 1,440 kilometers of pipeline work construction to do. And you're talking about $3.5 billion US project. And now this comes with other subsidiary works that come along the pipeline works. That alone, you have the refinery projects that are going to happen in the north of the country. So there's huge opportunity coming into the region where all players and all participants can get ready to participate. Leave alone the construction of the pipeline and the refinery, even the exploration works are also still wide open. So much has not been explored. So all these are opportunities that should be welcome. Going forward, you also have the power sector that is still so low and efficient. So much is still needed in that sector by new participants. Also to point out is that in the last 8 to 10 years, the region has seen organizations coming up. You have player associations building. You have building and civil engineering contractors associations building up, formed. So it becomes easier for new entrants in the market that, yeah, you get into the region and you can have subcontractors, you have local players in the market. I mean, and I think I don't remember who was bringing it up, that most procurement laws we're having in the region encourage local participation. So it's going to be a bit easier for the new participants that when I come into the region, who do I partner with? Because these have been profiled by the associations, local associations, by the local procurement authorities. So then it is easier for you when you're a new participant in the region. Who do I partner with? What is their capacity? What is their undertaking? What risk can I apportion to these people? So that then you do not start off from what new participant faced 10 years ago, where you come into the region and you do not have a starting point, then you probably had all your risk factors wrong, and then the project is a very big problem. Now, right now, the region has been organized to some extent. You have all these other incentives that governments are giving, especially for contractors who are financing projects. So this is being encouraged across the region. So this is going to make it somewhat softer for the new participants in the region. Thank you so much.
Thank you very much indeed, Paul. And it's very interesting, this theme of the contractor as sponsor, which we've heard a few times. Amin, would you have anything to supplement to Paul's answer as to new entrants?
Yeah, sure. So I think in terms of new entrants and opportunities, I guess firstly the proof is in the pudding, and like I said earlier, the number of new players that we have seen from private equity lenders, contractors from India, Japan, China, and a number of countries. You know, we've seen players like Bechtel from the US who were previously not here. Marubeni and Fuji are involved in construction projects in Kenya, previously not here. Sterling and Wilson and Shapoorji from India, again, involved on the ground on projects previously not here. And, you know, numerous Chinese contractors and developers. So, and then on the private equity fund, you know, Actis, Helios, ECP, etc., getting involved in, you know, what are now, you know, infrastructure, real estate projects that typically they wouldn't be involved in. So we see this, again, the opportunities coming going forward on the public-private partnership side, where we believe with government balance sheets being stretched because of the debt they have taken on for the current infrastructure projects, and then further being stretched by COVID-19, we see increased opportunities in the PPP space. And more importantly, we see opportunities in what I'd call the non-traditional space. So you have seen a lot of transactions in transport and energy. But in terms of what we are doing right now, waste management, water and sanitation, government housing, social housing on a PPP basis with government that provides land, for example. You know, so currently we are looking at a number of these transactions that hopefully will have legs to go forward and get to financial close and commercial operation. But also on the purely private side, the purely private sector driven projects, you know, we are seeing industrial parks being developed by the likes of Improvon and Actis. We are seeing data center projects. We are seeing rollout of networks by the telcos with funding by the likes of European Investment Bank, Helios, to roll out telephone and data networks. So we see opportunities in a number of these areas. The other area potentially, depending on government policy going forward, but we see opportunity there, is potential privatization of state-owned entities in power, in energy, in aviation, where in telecoms, where I think either outright sales or bringing in additional investment into these state-owned enterprises could then potentially trigger a growth in development. We're, for example, working with the government in trying to restructure the aviation sector. You have an airline, you have an airports authority that is frankly in distress because of COVID. And how do you now restructure a sector like the aviation sector, which then continues to grow and develop in terms of projects in the airport sector, et cetera. And I think likewise in road, aviation, energy, we see a combination of PPPs and privatizations, assuming government will follow through on these policies. We see that, and frankly, we're seeing government policy already change or get better for the private sector. simply because of the impact of COVID. So one of the positives of what is a horrible event in terms of COVID is governments realizing that they are going to rely much more on private sector projects and privatization. So currently we are involved in what I would say outside the Kigali airport project that we are all aware of, but another project that's potentially, in my view, one of the largest projects in Kigali. And through the COVID period, we have been negotiating with government, and it's incredible the support that we have seen from the likes of the Rwandan government in terms of getting us access to different governmental authorities. So if you have an issue around sewage, water, power connections, etc., roads that impact your project, it is actually, pleasant to see how the Rwandan government has been so efficient in coordinating all these aspects to develop projects. On the Kenyan side, again, we have seen, whilst there are issues in terms of what we think government policy could be going forward, again, we have seen coordinated efforts by the government of Kenya to deal with existing projects that have been impacted by COVID. And I think that government action in terms of providing stability, in terms of providing and dealing with interface risk within various governmental authorities has certainly been a positive that we have seen over the last few months, because I believe governments are realizing that the old model of government debt and government procured projects is not sustainable in the long run, and a proper interaction and dealing on a structured basis with the private sector is going to be fundamental to continue with the growth of the infrastructure space and the construction space.
Thanks very much, Amin. I'd now like to call upon some of the rest of the panel, some of our esteemed panelists whom we haven't heard from. Yes, this is picking up on that sort of sectoral balance. The transport sector has certainly accounted for a huge amount of total construction projects in the East Africa region. And I would just invite our panelists now to comment on the impetus, the momentum behind that transportation development boom, if I can call it that, and whether you expect to see the same sector emphasis on transport, or whether you think other sectors are now coming through to rival it. And if I might start with Papayas first to give us views.
Thank you so much. Is it possible to share my screen?
Let me just check with our IT team, but I think it should still be enabled. Is that right, Mansoor or Shivani?
Yes, Papayas, you should be able to share your screen.
Thank you. Can you see it now?
Yes,
we can see it. Thank you.
Thank you very much. I will not repeat what my previous speakers have said, but basically, as like you have asked me, the transport sector, we know that is an enabler for other economic sectors to flourish and prosper. This sector includes, of course, the ports which you had that expansions are going on, especially on the East African coast, Kenya and Tanzania. We understand that there are so many road projects at national levels and cross borders in all East African countries. There are railway projects, some of them have started and others I think are already in use, but still they are going on. Airways also is being improved. You have heard of Kigali Airport project that is being done. You heard of Dar es Salaam Airport that has been expanded, Nairobi. So all this is because the transport sector is the basic requirement for other sectors to grow. Implying that it makes the derivatives of these sectors that we believe, you will see that after the expansion or the growth of the transport sector, the other sectors that are potentially to grow in the East Africa is agriculture, is mining, is manufacturing, tourism. Services also are going to expand. Trade and urbanization, as you might find. Now, I think my previous speakers have spoken about the project and the infrastructure, but this I would like to emphasize on the situation that probably are found mostly in the East Africa. This is the size of engineering projects or construction projects in East Africa has been stagnant for many years, and this renders the local engineering consulting firms unable to compete nationally and regionally. This also includes the contractors. Consequently, many mega projects are led and implemented by foreign engineering firms. East Africa engineering consulting firms also lack the capacity for the big or mega projects, although some countries may have individual capabilities in small specialist firms. I have identified about 11 challenges, which I'm going to take you through. East Africa, local companies that consulting firms and the contractors, you find that they are small and fragmented to serve on those mega projects. There is lack of motivation and determination to create sustainable engineering consulting firms. There is lack of capital for growth and expansion. There is another challenge where you find talented East African firms end up providing cheap labor to international firms. When it comes to these mega projects, you find that those talents are either not there in the East Africa, going for other opportunities elsewhere. Then there is an outflow of money due to imported services by the contractors and consulting engineers. Then there is lack of making the countries, our countries, or the economy stable, not able to grow to the level of exploiting the services. Another challenge, of course, is the constant raising of the project costs. This is probably, I think, and believe it is due to the institutional disconnect. In the East Africa, especially Uganda, Tanzania, Kenya, Ethiopia, we have engineering and regulations that regulate them, both contractors and consultants. But you will find that when it comes to the implementation of those projects, there is a gap between how they relate, especially at bringing the cost together, bringing the cost to be reasonable, you find that there is that kind of disconnect, as you can figure it out in the figure that is in front of you. Another reason, of course, is the corruption issues, where you find that, of course, there are companies that have dominated the market, especially in the construction, and most of them are foreign companies. And looking at the whole formula of the corruption definition, where it's defined by the monopoly and discretion minus accountability, you will realize that the nature of the project, of the construction projects that take place, involves a lot of discretion. And because the ones that who are accessing on that market are few and foreigners, you realize that projects get and continue to be more expensive, and the outflow of money continues, simply because that connectivity or the connection between the public sector, the private sector, and the professional bodies. Does not imply that there is no that connection, but rather at different, in all countries, the implementation is at different levels. But when you discuss at individual country levels, you realize that that gap still exists. Then there is a lack of skilled labor. Of course, when you take the cycle of the project, you understand that it requires, every stage of the project requires specific skills. And once the skills have not implemented or put from the starting phase to the closing phase, that's where you realize, you find that there is variation of prices. There is always, it always becomes all the cost goes to the client, which in this case for mega projects goes to the government. And whereas we feel that if there has been a good collaboration between the private sector, public sector, and the professional bodies, this level of skills from the local expertise would contribute by so much, especially in bringing the cost down and even creating sustainability for the operation and maintenance of this infrastructure. Then another challenge is the low level of compliance to the occupational safety and health standards, especially in the construction projects. That's a risk in the sector. Then local content is not properly implemented. In some countries of East Africa have regulations that talk about them, but when it comes to implementation and enforcement, there are still a lot of gaps. Then there is insufficient institutional collaboration, where you find that lawyers, engineers, architects, and all other professions are allied in the profession. You find that they are also disconnected. There is no proper framework that where they would share information and probably be at the part of making things much better than they are now. Then there is, of course, the mistrust between the professional institutions and governments. Sometimes in some countries, governments see professional bodies as probably the pressure or something that would always be in the opposition. And so there is that bit of not agreeing in what they want. Then there is valid commitments. Of course, in East Africa, you well know that there is a mutual recognition agreement, which was signed by the heads of governments. But when it comes to the implementation, again, there is a bit of gaps. Each individual country has other requirements that are not stated in the mutual recognition agreements, and this limits the movement of the professionals' practice as was accepted by the heads of governments. So in short, that is the summary that I think are the unique challenges the East Africa region construction sector faces. But I do understand that there are some initiatives to work on them at individual country levels, but still a lot more is needed. And I thank you so much.
Thank you very much indeed, Papias, and an incredibly helpful checklist and some solutions, not only problems, which is always always great to hear. Now, just to check with you on timing, I must give Suzanne an opportunity to speak. So if I may, I'm going to just use the remaining time for our session over the next 5 minutes or so to give Suzanne an opportunity to share some of her views. I think in the timetable, we were due to have a break from 2:15 to 2:20. If you don't mind me treating that as float for all you construction professionals, I may do so. But Suzanne, thank you for your patience as we come to you. And you have free choice as to which topic you might choose for the remaining time. So the options I'm pleased to present to you would be a comment on how the region has responded to COVID-19, or alternatively, a shift away from governments funding most construction projects and how, if you like, the funding landscape might be changing. I regret to say I can only let you choose one or the other, but you do have a few minutes to give us your views.
Thanks, Angus. I was wondering what was happening with time being a significant factor in our industry. It seemed to be at large, but I'm glad to have a few moments to share some thoughts. I think the previous some of the previous speakers have highlighted some of the things which are happening in the funding space in terms of new entrants and new models, participants who previously would have just been involved as contractors bidding for either government financed or MDB, multilateral development bank financed projects, now bringing money to the table. I mean, we're seeing this trend of, you bring your money to the pot, come with your own beer. You bring your money and you do the projects. What I think is happening, I mean, obviously the kinds of projects that are getting a lot of traction are those which are well harmonized with the African Union vision, the 2063 agenda, which of course is about integration in Africa. And so when you think of the level of physical integration, that sort of speaks to why transport projects have had a lot of traction. But they also, those projects that align with the Sustainable Development Goals, because you will find that the funding which is available internationally will be oftentimes benchmarked against what they contribute to achievement of the SDGs. So really, in infrastructure poor regions, which relatively we are in the East Africa region, I mean, not if we compare perhaps to Southern Africa or some other or Europe or other parts of the world, we expect that government will continue to be a major funder of infrastructure projects, but the goal might be shifting more to a mobilizer of funding, if I could say so. So we will see from this integration perspective that the projects which connect us not only physically, but also as we are operating in this space and in the ICT areas, we will find that those kind of projects will move forward. There will be many private players who will want to participate in that space because it facilitates other possibilities. So of course, there's a lot of private money for extractives. People want whatever the geological lottery has bestowed upon us in this part of the world. So we will find that for those extractives to go ahead, you will find that other private financiers will come in to fund power generation projects, which will be to dedicated private off-takers. And then piggybacking on that, you may have some of the government projects to smaller grids, to the ones which aren't particularly cost reflective. So I think in the ICT space, the private investors will come in because it enables so many other aspects of commerce and that integration. So getting those gateways fully connected across Africa, that's going to bring in a lot of private investors. I mean, I have even seen people who would normally be in the space of just participating in construction on the contracting side, looking to fund, to put their money into feasibility studies in agriculture, in all kinds of various sectors, trying to see what projects can provide money, so that they then come in on the infrastructure development angle of it, and then the aspect of actually the commercial developments will follow. So there's a lot of shifting, tectonic shifting in the funding space. And I think those who are looking at the various value propositions, whether it is in rural developments, but whether it is in agriculture, whether it's in extractives, whether it's just in for example, developing logistics hubs, which will service these connections, which will be happening across the continent. I think those will be, these projects will start popping on people's radar. And there are a lot of people who are already working in the background of trying to develop projects which are ticking all the boxes in terms of the African Union agenda. We're looking for the new PIDA 2 list, as well as Sustainable Development Goals agenda, so that we can be the first, the first takers for the development finance, which is available from private as well as multilaterals. Thank you, Angus.
Thank you much. Thank you so much, Suzanne. I would love to take longer to draw together some of those themes, but I'm sorry to say we have started to take time from another party working on site, so to speak. So I should wrap up there and thank all of our panelists. You've done a great job with some very big picture questions. And of course, before passing on the torch to the next runners, I'd also just like to thank the ACL for putting together such a spectacular event. So then greetings to our very good friends at Oraro and Company, and we'll hand over to them for the next session. Thank you.
Well, thank you very much. That should be me. Ademola, are we giving attendees a break at this point?
No, I think we should go ahead. Yeah, the attendees look like they are going strong, so we may as well continue to go strong too.
Okay, thank you very much. Now, I have the privilege of addressing you today on Kenya's public procurement process. My colleague Pamela Gare concisely gave you a snapshot of Kenya's construction industry. And as part of her comment, she said that the government procured projects account for 60% of the total projects in our construction industry. The bulk of those projects are not PPP projects, they are government procured. And the system used is our public procurement legal framework. Kenya has gone through 2 waves of regulatory reform for its public procurement system. The first was before our Constitution of Kenya 2010, and the second was subsequent to it. Our Constitution mandates that our public procurement system be cost-effective, efficient, transparent, and equitable. amongst other key principles. And it sets out a number of key considerations that must be taken into consideration in public procurement. These are the degree of control of the principal, the duration of the project, any foreseen changes, the nationality of contractors. I believe quite a number of earlier speakers have talked about a preference for local contractors. That's no different in Kenya. And like with all other sound public procurement systems, financial evaluation and technical considerations are key determinants in all the public procurement methods that are enshrined in the legislation. Our public procurement process is broken into three: the pre-tendering stage, the tendering stage, and the award of tender. Now, for many of you who are actually specialists in this field of construction, you're well versed with this process. But I'd like to give the schoolgirl explanation, just because it will make the discussion later a lot easier. So when a procuring entity or a public body wants to conduct a project, the procuring department will determine preliminarily the technical specifications of the project and will create an initial budget and will scope all resources required for that project. Thereafter, it will be sent to the board of that institution for approval. If approved, then it will be sent to the parent ministry for approval at that stage, and subsequently to the National Treasury. The National Treasury will pay key consideration to the financial terms of that arrangement. If it's a debt arrangement, then the terms of the debt will be strictly scrutinized. And if it's off that the government balance sheet, then whether its affordability will also be closely scrutinized. Once approved at that level, then it goes back the same way, back to the parent ministry, then to the institution, the government institution, before beginning the tendering stage. Like in many other jurisdictions, advertisement is key. And there's a requirement to advertise in at least two newspapers with national circulation. If international contractors will be required or are sought, then publication has to be in publications with international circulation. When initial bids are received, the evaluation process will begin. There's usually a tender evaluation committee in every public entity, or at least so it is hoped. But where there is none, then an ad hoc committee is constituted for this process, sometimes accompanied by an assessment committee. These two committees will create a shortlist, and shortlisted candidates will be invited to bid. Then the second process of evaluation will commence. A detailed evaluation report will be sent to the tender committee following request for clarification, and at this stage, once concluded, the award of tender is made. In terms of challenging the award of tender, Kenya's legal process requires that it must be done within 14 days of notification, and challenges are sent to the Public Procurement Administration Review Board, and that challenge must be determined within 21 days of being filed. It's been a very successful process in Kenya, and I think out of all the processes we have in public procurement, that's the one in which we get least complaints. Now there's a preference for open tendering in our public procurement law. However, as you can see in this slide, there are multiple procurement methods that can be utilized. The two-stage tendering process, for example, requires that technical bids be submitted first, and those that are shortlisted will then be invited to submit their financial bids. Design competition, on the other hand, is used where creative services or creative process is key to that procurement. Restricted tendering, many of you know, this is only where the procuring entity already has a pre-qualified list of tenderers. And direct procurement, which in Kenya, the most scandals arise out of, is only used in exceptional cases where there's either a catastrophic event like war, invasion, or in the recent past, COVID, a pandemic like COVID-19. In terms of standard forms, it's important to note that tendering documentation is standard. However, the contracts are not. In terms of construction contracts, there is a preference in the market for the Joint Building Council contract, or JBC contract as it's known. And of course, FIDIC contracts are widely used. In terms of common structures for projects, I'll talk about corporate structures because joint ventures are widely used, both incorporated and non-incorporated. And consortiums are also widely used in the market. A number of key considerations go into not just the corporate structure, but the transactional structure of the project. And that's its complexity, its duration, the relevant industry, and the relationship of the parties, which is, in an industry, the relationship between the procuring entity and contractors. I've set out in this slide common arrangements for large infrastructure projects in Kenya. You can see that the build, operate, transfer sort of model is widely used. I'll talk a little bit about where we are right now in the market. Following our Constitution of Kenya 2010, county governments also became procuring entities. Now, our Office of the Auditor General has consistently reported that counties do not apply our procurement processes strictly across the board. This differs from how national government entities apply public procurement law. And I guess the key difference there is that, national government bodies have gone through that process even before the Constitution of having to comply with public procurement law. And then going forward, there's a push towards ensuring that county governments do comply and not only opt for direct procurement, which seems to be a favorite amongst county governments. That's it from me. I look forward to hearing from anyone who may have any questions. Thank you.
Thank you so much for such an insightful talk. I would now like to introduce Arun Veluswamy, a partner in Hogan Lovells London office's Infrastructure, Energy, Resources and Projects team. He will be discussing the financing considerations for construction projects in East Africa.
Thanks, Shivani. Let me just put everything in order. So I'm going to share my screen. Hopefully you can all hear me okay. There you go. Okay, so welcome everybody. My name is Arun Veluswamy. I'm a partner in the Energy and Projects team at Hogan Lovells in London. And I'm going to speak to around 10 minutes on the subject of financing construction projects in East Africa. There's really no magic to financing construction projects in East Africa as opposed to anywhere else in sub-Saharan Africa, but there are a lot of common themes that we can draw. So the purpose of this presentation, my presentation, is to identify some of the key requirements that lenders financing construction contracts will be seeking. Some of these have been mentioned by other speakers, but they're so fundamental that it is worth dwelling on these, and I hope to go into a little bit more detail on some of them. So the first slide is a structure for a construction project for a thermal power plant. And this is a structure that many of you will be familiar with. In the center, you have the project company or the employer under the EPC contract. The lenders on the left will provide funding to the project company, and the project company, in addition to its own equity investment from its shareholders, will use the debt funds and the equity funds to pay the EPC contractor under the EPC contract, which is in the bottom left of the screen. The EPC contractor, in addition to entering into the EPC contract with the project company, will also enter into a direct agreement with lenders. And the purpose of the direct agreement is to protect the lender's rights in circumstances where an EPC contractor may have the right to terminate the contract because of a default of the project company. Given that the lenders will typically have funded up to 70% of the construction cost, they want to know that in circumstances where there's a danger of the construction contract being terminated, they're able to step in and keep that contract going and to preserve the value of their investment. The next slide covers some of the key things that lenders either require or prefer when considering financing construction projects. First of all, the form of the contract. It's open to employers and contractors to use any form of contract that they want to, but it's certainly preferred by lenders, and it makes the lender's due diligence process easier if the parties adopt an internationally recognized standard form. For power plants, for process plants, the FIDIC Silver Book 1999 edition is very commonly used. There are a standard set of amendments that lenders like to see made to the FIDIC Silver Book, and it's one that's been banked in numerous projects around sub-Saharan Africa and internationally. The FIDIC Silver Book is also typically structured as a lump sum turnkey project. What do we mean by that? Essentially, the contractor acts as the single point of responsibility for performing all of the design, construction, and commissioning works. That's obviously attractive to lenders because one party is responsible for the whole of the construction works. And if something does go wrong, there's one party wrapping the entire performance, as opposed to having to go after multiple suppliers and multiple contractors in a construction management type structure. In terms of performance, if the contractor fails to perform, the financiers, lenders will expect to see remedies flowing to the employer. For delayed completion, you typically see liquidated damages, and these are designed to compensate the employer for loss of startup, loss of revenue from a late startup. And often these liquidated damages can also be used to pay the first repayment to lenders. Similarly, with liquidated damages for performance, if the plant is meant to operate at, for example, provide 100 megawatts of capacity and it only ends up providing 95 megawatts, then there is a shortfall in the revenue that the project and the plant will generate, and that needs to be compensated. Now, it's all well and good having these damages remedies against the contractor, but the lenders will not want these damages to be payable after, for example, a 2-year arbitration process or an expert determination process. So it's therefore very common and a lender requirement that the liquidated damages will be backed by a liquid on-demand unconditional payment security. Linked with sort of credit enhancement of the construction contract, many contractors in Sub-Saharan Africa will incorporate a local company to carry out the construction works. And because that local company doesn't have much of a balance sheet, lenders will expect to see the parent company of that local contractor providing a full parent company guarantee. Now, we've mentioned that there will be certain liabilities attaching to the contractor for non-performance. No contractor is going to accept unlimited liability. So it's typical that the liabilities will be capped. And there are a range of caps that can apply: separate caps for performance liquidated damages, separate caps for delay liquidated damages. But it's important that these damages caps fall within what the lenders consider to be commonly recognized industry parameters. Now, the ultimate sanction, should the contractor fail to perform the works, either by a long stop date, or if the performance of the works falls below minimum thresholds, is the right for the employer to terminate the contract and to ask for its money back. And this is important for lenders because the money back means that they do have a means of having their debt repaid, even if the plant itself is not functional. I mentioned direct agreements. This is very standard, something that lenders ask for. And sort of as an overarching thing, and I know this has been mentioned before, the risk allocation for the construction contract needs to be bankable. And by that and what do we mean by that? Essentially, the basic principles of risk allocation are: what are the risks, which party can best control the risk, which party is best placed to bear the risk, and what are the consequences of that risk should it arise, who benefits and who suffers. These are some of the key risk allocation areas that need to be addressed in EPC contracts, and it's very important to lenders that these risks are allocated in a way that they're comfortable. I've mentioned design previously. This is something that the lenders will expect the EPC contractor to take full responsibility for, even if the employer has prepared some front-end design, a feed, so to speak. In those, the lenders will expect the contractor to have reviewed and verified that design and take responsibility for it. Similarly, when it comes to constructing on site, if the contractor hasn't had the chance to conduct its own site study, if the employer has provided that site study, it's up to the contractor to get itself comfortable with that. Lenders certainly expect contractors to take site risk in most projects, not all. For example, with hydropower projects, it's typical for the employer to take geological risk rather than the contractor. Force majeure events are another major category of risk allocation. These are events beyond the reasonable control of either party. They fall within natural force majeure events and political force majeure events. Effectively, if one of these events occurs, the party affected is excused from the performance of its obligations. In the next couple of slides, we will look at this in a little bit more detail. I mentioned the EPC contractor's credit risk. This can be managed both through the provision of performance bonds to back liquidated damages and the parent company guarantee. Variations, any change to the scope of the work or the timetable for the work will constitute a variation, and that will, if that's requested by the employer, that's something that the employer will need to either provide additional costs or provide an extension of time. Where there are additional costs, and this doesn't fall within the contingency of the financing, lenders may require that the employer's shareholders will provide that additional financing to fund the cost overruns. And supply risk, one of the key things I mentioned earlier is that the lenders like to see a single point of responsibility. So any delays to materials or goods that are going to be used in the construction of the plant, that risk needs to remain with the contractor who's responsible for the supply chains. I mentioned natural and political force majeure events. These are typical examples of both of these events. So just to summarize briefly, political force majeure events are essentially those things that we call, you could term them as country risk. And these are not risks that contractors generally agree to, and lenders wouldn't expect the contractor to agree to these risks, to the extent that one of these political force majeure events does occur. Then the contractor will essentially be entitled to a variation, allowing it to, if appropriate, increase costs and also excuse from performance, perhaps an extension of time. With natural force majeure events, it's generally not the case that the contractor would be entitled to increased costs, but they would be entitled to an extension of time. And sitting above this all, or alongside it, is the insurance package for the project. In addition to risk allocation and risk mitigation within the contract itself, lenders will expect there to be a comprehensive insurance package covering many of the risks listed and many of the force majeure events listed. Not all, there will be some risks that are uninsurable, but the more that can be insured, the better as far as lenders are concerned. And the lender's security package for their financing will extend to cover the insurance proceeds. This slide summarizes what I've said, extensions for the different types of force majeure and other events, extensions of time, additional costs, relief from performance. I won't dwell on this. And then one thing that is worth mentioning is the concept of back-to-back and equivalent project relief. Whereas the contractor will be entitled to certain remedies and for force majeure and other risk allocation events, and where the employer is responsible for those increased costs or providing extensions of time, lenders will want to see that those additional costs and extensions of time can be passed through to another party. In the case of a power plant, the project company will have entered into a power purchase agreement, typically with a utility, the national utility. So under a power purchase agreement. And under that power purchase agreement, the utility will agree to purchase the offtake of the plant from the project company or the employer. Usually, and almost inevitably, the power purchase agreement will provide for reliefs for the same events that may have affected the EPC contractor. So if an EPC contractor has been affected by a political event, lenders will want to see that the power purchase agreement provides relief to the employer for that political event. And so it's common in EPC contracts around Africa to see an equivalent project relief clause. And essentially this clause states that to the relief that the contractor will be provided under the EPC contract will be no greater in scope, duration, and quantum than the relief provided under the head power purchase agreement. So I've gone through very quickly in relation to some of the key factors and key things that lenders will look at when financing a project. And I'll draw it to a close at this point because I'm aware that I'm running slightly over time. So I'd like to thank you all for the opportunity to present on this topic. And I hope the rest of the afternoon is as constructive as I found the first few hours to be. Thanks, Ademola.
Thank you so much, Aaron, for such a clear and engaging session. I would next like to introduce Ademola Bambosi, an associate from Hogle London's London office in our international arbitration team. He'll be discussing the key considerations when negotiating a dispute resolution agreement.
Thank you so much, Shivani. And hello, everyone, once again, and thanks for joining this session. Like Shivani rightly mentioned, I'm an international arbitration lawyer in the London office here at Ogunluvels. I'm also a member of the Global Africa practice, and I'm privileged to be a director at Africa Construction Law. So yeah, I'm here in two capacities. About 80% to 90% of my practice is actually Africa related. And so what I'm hoping to do today is share a bit from my experience doing arbitration in Africa, especially in the context of construction contracts. Next slide, please. In this session, I'll discuss some of the key tips, like Shivani rightly mentioned, that you should have in mind when negotiating arbitration clauses, especially in the context of the African continent. Dispute resolution clauses are often relegated to the end of contractual negotiations, or many times just dismissed as boilerplates or given standard wording without any thought, as to the context. But we need to understand that these clauses have profound implication on how a dispute is resolved, and also affect how the contractual rights and obligations in a contract are enforced, especially in the event of a dispute. In case you've not noticed from my very, very strong and thick, wonderful Nigerian accent, I'm African. And as Africans, I think I've noticed that we generally don't think about disputes when we're starting new relationships. I'm aware of various African adages that clearly show, our aversion as a people to anything related to contentious proceedings. It's almost as if we try to avoid thinking about contentious proceedings until we absolutely have no choice but to do that. The reality, however, is that dispute and contentious proceedings cannot be avoided altogether. I'm presently advising a leading African client, East African client actually, in relation to a dispute proceeding with a US government fund. And both parties came together to run their JV. The relationship went on well for a long time. And it was not until the tail end of the JV that the dispute arose. Now, both parties who successfully ran, the JV together suddenly cannot even agree on, little things like meetings. And so I guess that emphasizes the importance of the dispute resolution clauses. And, as much as possible, we should try to bottom these things out when parties are still talking. Now, there are a number of dispute resolution options open to parties, but in this session, I would focus on arbitration, which is arguably the most popular method of resolving, international construction contracts, arguably. Now, let's go back to the basics. Shivani, the next slide. An arbitration agreement records the consent of parties to submit their dispute to arbitration. And so, as you would probably know, it's usually a clause in a main contract, even though it can be separate from, the main contract entirely. This means that if the principal contract fails, the arbitration agreement may remain valid and binding. This is the principle of separability. I won't go down that line. Now, the arbitration agreement will typically define the scope and the conduct of the arbitration. And there are a couple of key issues which I'll be discussing, which I think that your arbitration agreement should contain. And I'll be trying to provide you with a bit of context as to why you should be very deliberate when negotiating this. Next slide, please. The first element I'll discuss this afternoon is the seat of arbitration. The seat, or what some other people call the legal place of the arbitration, it determines which country's law governs the arbitration process. So for example, by selecting London as the seat of your arbitration, the parties place the arbitral process within the framework of English laws and courts. The implication of this is that not only does the law of the seat affect the various procedural aspects of the arbitration, in the event of a challenge to the validity or effect of an award, the designated competent court within that seat will deal with any such proceedings. Now, from a very practical point of view, you want to be very careful when choosing a seat. As a potential award creditor, you've gone through the arbitration, you've won. You want a seat where the courts are generally supportive of the arbitration process. You want a seat with a developed legal system. You want, a seat with, a generally modern approach to arbitration. You also want to look at the antecedents, and the general approach of the courts in your, proposed seat to arbitration. You want a seat where there are no delays in the administration of justice, because you don't want your case to be stuck in court for 5 years for what can easily have been resolved in the courts of another jurisdiction in 3 months. I'm not going to mention any country, but the guilty parties should know themselves now. You want to be able to approach the courts and get, an order enforcing your award as quickly as possible. In addition, I think one other point to add is that, because construction-related disputes are, sophisticated, you want a jurisdiction with courts that are used to dealing with sophisticated disputes and at the very least understand what is at stake. So these are some of the issues you should have in mind when negotiating your seats in your arbitration agreement. Next slide, please. I think the second issue I'll discuss this afternoon will be the law governing the agreement to arbitrate. One practical consequence of the doctrine of separability is that the governing law of the arbitration agreement, that is the law which determines the validity, the scope, and interpretation, can actually be different from the governing law of the broader contract, the head contract in which it is contained. And it can even be different from the law of the seat of arbitration, actually. So for example, many of you would know the Sulamerica case, the English case, where the English Court of Appeal held that while English law was the governing law of the arbitration agreement, Brazilian law was the law of the head contract. So I think that emphasizes that there could actually be different laws operating in one single contract. Now, based on recent decisions in England, I would always advise people to expressly stipulate the law applicable to the arbitration agreement. Some of you would be aware of the Enka versus Chop decision. I won't go into that. But what I would say is that while the decision, brings a little bit of sanity to an either too muddled area of law, the point still remains that in a typical international contract, there would be a couple of competing legal systems, including the law governing the contract and the law of the seat. Now, while I know that the laws of our various jurisdictions may adopt a different approach to the position in England, it is still prudent, to express the law governing the agreement to arbitrate, irrespective of your jurisdiction, in order to avoid unnecessary costs, wasting unnecessary time. You also don't want a situation where, the tribunal or court, in the event of a dispute, they choose a law that was outside your contemplation as at the time you were negotiating. So it makes sense and it is prudent for you to just expressly stipulate this. Next slide, please, Shivani. Now, whether the tribunal will be ad hoc or institutional is, another important decision that parties have to make. Okay, I would go back to the basics again, and I would quickly differentiate between ad hoc and institutional arbitration. Now, ad hoc is an arbitration where parties establish their own rules of procedure, and in practice, what I've seen in practice is that when parties opt for this option, they would usually choose the unsitual arbitration rules, which contains a sensible and well thought out framework for parties to use. Institutional arbitration, on the other hand, is one that is administered by an arbitral institution, under its own rules and of arbitration. In my experience, a good number of international arbitration users favor institutional arbitration. That's my experience. And even in situations where parties have opted for ad hoc arbitration in the arbitration agreement, one thing I have seen a number of times is for parties to pay institutions or to engage the services of institutions like the PCA or the LCIA to administer the arbitration, even though parties are not, using the LCIA or PCA's rules. So what they basically do is they engage the LCIA or the PCA to provide secretarial or administrative service for parties to use their services, even when not using their rules. Now, there are a number of arbitration institutions for parties to choose from. And because of this, we need to be careful, very careful when choosing an arbitration institution. Next slide, please. Now, so what are some of the factors that you should have in mind when choosing institutional rules? Number one is you want an institution with modern rules of arbitration. Now, it's difficult to determine this, especially because your dispute can arise many years down the line. But one thing to know is that the practice of international arbitration, it changes rapidly. And so new rules and procedure come into place all the time. The way to determine, the future, at least in my own opinion, is you want to look at the track record of the administering institution in updating their rules in order to ensure that your selected institution is responsive to developments within the field of arbitration. So let's take, for example, COVID-19, and the increase in the use of virtual hearings. You want to ensure that your selected institution is able to move with the times, especially because you don't know how many years down the line that your dispute will occur. So you don't want to be using rules made in 2002 for a dispute occurring in 2021. Obviously, there will be gaps in such rules. As you would expect, a number of developments would have occurred between 2002 and 2021. So you want to ensure that your selected institution is responsive and moves with the times. Another factor to have in mind is charges and fees. Now, while some arbitration institutions would calculate their own fees and expenses by references to the amount in dispute, some others assess their fees based on the time spent on the case. So that's something to have in mind. I don't have a preference, but I know people who have preferences, so that's something else to have in mind. Another factor is specialized staff. Is another important point to note. Some arbitral institutions adopt a hands-on approach to the conduct of arbitration, while others leave matters to the arbitral institution to take a lead, to basically just do, take a more prominent role in whatever goes on. In addition, some institutions would go, and review their award in general to ensure that there's nothing obviously wrong with their award. This helps to reduce, the number of challenges in relation to the arbitration. The fourth factor that I would consider this afternoon is permanence. And, it's somewhat related to modern rules of arbitration. And, disputes between parties to a construction contract, many times arise many years down the line. And you want to choose a genuine institution. And what do I mean by a genuine institution? You want to choose one that has been around for some time, and or even if not around for some time, run by people, credible people you know. So if I was negotiating an arbitration agreement and the other side were to mention an institution I was not aware of, I will check the people on the board. I'll check, what's the institution's track record? Who are people associated with the institution? All these checks, they are necessary because if for any reason your institution is not in existence when your dispute arises many years down the line, parties run the risk, of the agreement being considered to be inoperative or, incapable of being performed for obvious reasons. Next slide, please, Shivani. Tribunal selection, getting the tribunal right. Now, the arbitrators who compose a tribunal, sorry, Shivani, you can go to the next slide. They are not simply passive figures who at the end of the day just render an award. These are people who interact with each other. They interact with the parties, witnesses, and the expert witnesses too. They set the procedure, they set the timetable of proceedings, they issue decisions on crucial issues such as the scope of disclosure, and sometimes they can even participate in examination and cross-examination of witnesses depending on their background. In practice, parties would many times usually specify the number of arbitrators that they would want. And the effect of this, maybe I should go into the effect of the numbers 1 versus 3. The effect of a 3-person tribunal will typically mean that the arbitration may take longer and you would obviously spend more. A sole arbitrator, on the other hand, just needs to check his own diary to determine, when hearing should hold. But, 3 arbitrators would have to arrange, meet and get dates. And that could be very difficult, especially when you're dealing with lawyers, tribunal, witnesses, and all that. Also, when writing the award, a sole arbitrator just focuses on the task without consulting with the others. It goes on very fast. But three arbitrators need to take out time to discuss and agree. Now, on the other hand, when you have a dispute that is complicated, and involves, there's a lot at stake, you may actually want, a well-considered, balanced, and, robust decision. And this is particularly important when, the dispute is very complicated and there's a lot at stake. So, like I said, for me, there's no right or wrong answer. My point still remains that you should, you need to consider some of these issues when negotiating. As an alternative, I've heard of situations where people don't specify the number, and the appointing authority would then have to decide when the dispute arises. Like I said, I've heard of it. I've not actually seen it happen. But I guess one of the reasons for that would be that, depending on your type of contract, it's possible that the issues arising from that contract could be small disputes or large disputes. And so I guess it gives parties the flexibility. But these are the issues, again, like I said, that you need to take into consideration when negotiating your arbitration agreement. Finally, next slide, Shivani. The next slide again. Finally, I think the language of the proceeding is one issue that people many times take for granted. Well, I think the very nature of international arbitration entails, parties, arbitrators, and any other participant in the arbitral proceedings, they come from different nationalities, or they have different nationalities, they speak different languages. And so, the language of the proceedings are very important, especially in international proceedings or in potential international proceedings. But unfortunately, for some reason, people just take it for granted, and they don't spend time to negotiate this, important issue very well. Well, I mean, one of the reasons why you should definitely negotiate it is it provides a bit of certainty as to the procedural language. You don't want the first communication between parties to be, you don't want people communicating in different languages. And it in an international arbitration, where, like I said, parties are from different jurisdictions, it is very possible, because if English is someone's first language and French is another one's first language, you don't expect one to give to the other. And so these are kind of things that you should have in mind. The choice of the wrong language, again, can also result into translation and interpretation, or translation and interpretation when it is not necessary. Especially when most people speak a language and you then choose a language that is not relevant. One practical example that I usually give, and I'll give this in closing, is imagine a situation where company A is based in Italy, its parent company is based in the US. Company A signs a contract with company C, and company C is also based in Italy as company A. And what they then agree is it provides for Milan as the seat of arbitration. In choosing the language of the proceedings, company A is required by company B. Company B is the head company in the US to choose English language. The question is, if two companies have a dispute, the seat is in Milan, they both speak Italian language. The question that you start to ask yourself is there any real reason why they are picking English? What will then happen is that they may find themselves spending substantial money, doing translation, trying to get interpreters. Whereas, by looking into the future, they could avoid some of these things. I'm mindful that we're running out of time, so I'll just end this presentation at this point. But please send in your questions, and if we have the time, we'll definitely deal with it. Over to you, Shivani.
Thank you so much, Ademola, for such a comprehensive talk. I'd now like to introduce Mushtaq Nabdar Khan from BLC Robert Mauritius, who will discuss how to protect both the company and the project. Over to you, Mushtaq.
Thank you, Shivani. I hope you can all hear me well. I'll try to share my screen. Can you all see my presentation, Shivani? Is that?
Yes, we can. We can see it.
Okay. I'll just put
yeah, perfect.
Thank you. So I'm just going to cover very briefly some of the key risk aspects. I know that Aaron has covered a lot when he presented on lender risk appetite, but there is going to be some overlap. But maybe I'll focus on a few points that I've seen in practice. So risks are inherent in the construction industry for both the employer and the contractor. The smooth running of the contract depends on each party performing their obligations correctly. They also depend on consultants and third parties like suppliers. And of course, there are things that are beyond any person's control, like climatic factors, political risks, and recently, as we have seen, the COVID-19 global pandemic. I've tried to categorize some areas of risks, but obviously I disclaim that this is not an exhaustive list, and we cannot pigeonhole risk in specific categories. Of course, what is commercial risk can also boil down to be a contractual risk or a legal risk. But ultimately, I think that most of the risks would boil down to be contractual risks. The parties are experts in their fields. They know what happens in construction contracts, and at the end of the day, they have to do the best job they can to try to allocate the risk in the contract. With that disclaimer in mind, so what I've tried to set out some of what I've called commercial risks. Pricing and completion time, of course, are the things that the contractor and the employer have to think about. Understanding the nature of the project to estimate how long it can take to complete the construction works and how much it is going to cost. And pricing is quite topical at the moment, because with the COVID-19 pandemic, supply chains are disrupted and everything costs more to ship materials into the relevant country on the construction site. Labor is more expensive because if a project is dependent on the import of foreign labor in certain countries, then it is becoming more difficult to get the labor force on site. That takes us to supply chains. We have seen, for example, at the beginning of the pandemic last year, how many construction projects and how many countries do depend on imports from China for materials, and China being the country where the pandemic originated. So there was an initial disruption of those supply chains from the People's Republic of China. So that has caused a disruption, and in time, you would expect that the market forces would be such that contracting parties would try to mitigate that risk and see whether there are alternative supply chains that they can use more locally, more regionally, in order to minimize the risk of something like that happening again. Of course, in 2020, COVID-19 took all of us by surprise, but a year later, next year, it will remain with us for some time, and people entering into new contracts have to consider how to mitigate the risk about supply chain disruptions. Environmental factors, this is usually provided for in the contract as to, for example, in the FIDIC 99, the Red Book, it is on the contractor to ensure that the construction works do not affect the environment on the site, also protect the environment off-site, to make sure that any emissions, effluents are within the factors specified in the specification, and also that they comply with the applicable law. But the key with environmental factors is that there will usually be an environmental impact assessment carried out before the project is started. Most certainly there will be a government body involved in granting that, in issuing that EIA, and contractors and employers as well have to make sure that at all steps in the project they are complying with the conditions in the EIA license. Now it helps to have a specialist engineer on the project in order to monitor the situation and to identify the risk as early as possible and to take steps to abate any potential risks that crop up. Contractual risks and any construction contract will first set out the contractor's obligations, the employer's obligations, the duties of the engineer, but a lot of the drafting is focused on how risks are allocated because there are so many moving parts in a construction contract that it is important to identify who bears the responsibilities and the risks of certain things happening. So if we take materials, labor, that is usually on the contractor. If there are disruptions, then it is important to identify whether the contractor can make applications for extension of time, for additional costs. Labor, again, is something that is usually on the contractor, but in the example of provision of foreign labor, there is an obligation on the employer to provide assistance as far as it can in order to help the contractor to get the labor force that it requires. Force majeure, Aaron covered that earlier in his presentation. If I take the Mauritian law that's where I'm from, how do you identify force majeure? Obviously, it is open to the parties to specify, to clearly define what they consider as force majeure. But we also have, under the Civil Code, force majeure and how it has been interpreted in Mauritius. And we draw inspiration from French case law on that interpretation. Usually you have three factors in force majeure, which is one, the event has to be something that was unforeseeable at the time of entering into the contract. Secondly, it has to be irresistible in that it was beyond any of the parties' control. And its effect is such as to make it impossible for one contracting party to perform its obligations. There is usually a third factor, which is that it has to be external, but case law has clarified that it is the irresistibility factor which is the key consideration in identifying whether there has been a force majeure event or not. Now, what is the effect of force majeure in construction contracts? Many contractors contacted me last year when Mauritius went through a first period of national lockdown. And obviously, in lockdown, movements were restricted unless people had work access permits. So that meant that workers could not be brought on site to carry out their work. And obviously, I think it's pretty clear that the contractor would be entitled to obtain an extension of time for that period of lockdown. But the key question that they were asking it was whether they are entitled to additional costs. And that boiled down to, under general law, the answer would have been no. But under the contract, you had to identify whether the force majeure event fell into categories that entitles the contractor to obtain additional costs or not. And again, the answer generally was no, because that didn't fall within the political risk force majeure events. So takes us to legal risks. Change in legislation, I put it in legal risks because that is, governments and parliaments adopting legislation that address the emergency of the pandemic. But it also overlaps with, it is also a contractual risk, because in the FIDIC record, for example, you would see that change in legislation is something that can entitle the contractor to obtain a variation on the price. It can entitle the contractor to additional time and additional costs. But the practical problems that I was seeing last year was, we have, for example, a Public Health Act, which was passed in 1925, and that act gave the Minister of Health powers to make regulations. The wording of the statute was worded in very broad terms, and empowered the minister to pass regulations as he sees fit in order to prevent the transmission and spread of an epidemic. Now, in Mauritius last year, there were regulations that were made that restricted the movement of persons except for very specific purposes. And the question was whether that was a change in legislation which entitled the contractor to claim additional costs. Some of my colleagues, some of my lawyer colleagues were taking the view that, well, because the regulations were passed last year, that could be interpreted as a change in legislation which prevented the movement of persons around the island. Others were taking the view that, well, no, the legislation existed since 1925. It was just an exercise of that legislation, although we had never seen that maybe in our lifetimes. But the minister was simply exercising the powers that he had under the Primary Act to make regulations to prevent an epidemic, and therefore that could not be construed as a change in legislation. So that was the debate that was going on. I haven't seen any formal dispute declared under that clause, or nor any court case, but there might be in the future, in 6 months or a year's time, we might see the disputes making their way through to arbitrations or court cases. Challenges to the contract and challenges at enforcement also overlap with each other. What I mean by that is in public contracts, there are situations that we have seen in the past where a certain company was awarded a contract by a government body for construction or other types of contract. Then you have general elections and the new government comes into power and starts scrutinizing what the previous government was doing. And there are contracts which were maybe not on favorable commercial terms for the government, which the government tried to see whether there were grounds to challenge the contracts or to terminate them. And one of the reasons that usually comes up is whether the contract, obviously entered into by the previous government, was in line with, was in compliance with public procurement legislation. And we have a case, not a construction case, but I think the issues can arise similarly in construction contracts. Was a contract of affreightment of petroleum products, where there was an exemption to the public procurement legislation, and the public body thought, and the private party thought that the exemption applied to the contract. It was entered into, it was operated for about 5 years. And then when the government changed, they terminated the contract. And in arbitration, one of the grounds that was raised on behalf of the government was that the contract was in contravention of public procurement legislation, in that it had not been approved by the Central Procurement Board. Now, the arbitrator found that the exemption was not, the exemption was applicable, and therefore the contract was validly entered, and therefore he awarded damages to the private sector party. The government challenged the award before the Supreme Court, and the Supreme Court carried out its own interpretation of the public procurement legislation and the exemption regulations. And it concluded that the exemption was not applicable, that the arbitrator had erred in making that finding, and that the court considered that it was empowered to go behind the finding of the arbitrator, even though it was a finding of law, because the Public Procurement Act is an act which concerns the public policy of Mauritius, concerns the foundation of Mauritian law, and that it was entitled to make its own assessment of whether the public procurement legislation had been breached or not. And the Supreme Court found that the exemption not being applicable, that indeed the contract contravened the Public Procurement Act, and it set aside the award on those grounds. The case has gone on appeal and was argued before the Judicial Committee of the Privy Council. And I think one of the arguments that was raised there is whether the court can make its own assessment of a finding of law and conclude that there's a breach of public policy because the Public Procurement Act was breached, or whether it should have taken a more narrow focus and consider whether the award itself was against public policy. So that was an interesting debate that took place before the Privy Council, and we are awaiting the judgment on that in the next few weeks or couple of months. So those were just some of the key challenge risk factors that I thought of. Obviously, as I said at the beginning, it's not an exhaustive list, and you would see from the previous presentation that there are broader risks that contracting parties need to bear in mind, and to try as much as possible to think of risk allocation during the contract, and if that is not possible, to think about mitigators that can be applicable to them in order to not to disrupt the construction contract too much. That is all from me. Thank you very much for listening.
Thank you so much, Mushtaq, for such a comprehensive session. Next, we'll be joined by Alistair Farr and Thierry Linares from FTI Consulting and Damien James from Damien James, who shall be discussing proactive project management. And Mushtaq, if possible, can you please stop sharing screen?
Oh, sorry. Yeah.
Thank you.
Okay. Shivani, thank you very much. Can you see the presentation?
I can, yes.
Okay, thank you. And we'll begin. Well, good afternoon, everybody. My name is Alistair Farr of FTI, and I'm joined by, in fact, just by Damien James, Damien James Associates, and we both run businesses which are involved on a day-to-day basis with projects in Africa and across the African continent. And we've got 15 minutes just to share with you to deal with the topic of proactive project management. And what we want to do is just explain some of the processes of the project management process, and also some good practice tips. And if we get time, we'd like to just run through a couple of case studies at the end. So there we go. So first of all, dealing with projects and what actually makes a project successful, and really that's really the starting point for our presentation. Well, there are many ways of measuring the project's success. Scope, was what was achieved, what was intended to be, first a starting point, and then secondly, is it schedule, very important consideration. Was it completed to time? And budget, was it completed to budget? And really, 2 and 3 are those aspects which are commonly, we find, end up in disputes, and really, bearing that in mind, we'll look at some of the processes that can maybe help to avoid that. Fourthly, quality. Did we satisfy the level of quality that was required under the contract? Fifthly, safety, very, very important, and to build the project safely without major incidents. And then, in fact, probably most importantly, client satisfaction. Was the client satisfied with what was actually built? And then finally, team satisfaction, because pride in the project team and what they've achieved is very important to the process too. Damien.
Thanks, Alistair, and thank you very much for allowing me to join you today. I just want to talk to you in respect of why projects fail or are abandoned in East Africa, really, in the first section of my slides, which is quite unusual, really, because both Alistair and I both work as quantum experts across the UK, Middle East and Africa. So it's more often than not, we're not normally found to be saying positive things about things. We normally find ourselves criticising. However, in the context of Africa, where I've been working for a considerable number of years now, project management itself is as diverse as the development projects which it's required in, and that applies from education, power, agriculture, and infrastructure. And we consider it from the perspective of both East African countries and the African continent as a whole. So when we think about the African continent, it is resplendent with brilliant, colourful, well-written development visions, policies, programmes, plans and projects, and we've talked to them briefly in this seminar this afternoon. But many observers often point out that it's the abandoned or the failed or the poor performing projects which are common in Africa And it's those projects themselves that have thwarted the appetite for Africa's development. I think from my perspective, and probably from many commentators' perspective, that theory is not the norm. And like many projects elsewhere in the world, projects in Africa are often late and over budget. The reasons for those, well, it suggests that the failure rates of African projects seems to be in excess of 50%. I tend to doubt this figure, as Africa project management has improved in my period in Africa, and it continues to improve. And we've talked to many positives in terms of dispute resolution today. But if we are going to consider the reason behind the failures and just to look at some of the common causes, well, we may look at insufficient implementation capacity. We may look at poor planning, and Alistair is going to talk to that again, and the lack of feasibility studies. Again, there's issues in terms of weak project design. And obviously essential to this discussion this afternoon is poor project management, and we'll talk a little bit more to that as we move through the slides. Again, Africa does suffer from political interference and changes in governments and their own policies. And there is the thorny issue of corruption. I tend to look at it as more of an economic and social issues, but corruption does exist in Africa, and it's a consideration which has to be considered or eradicated to allow further investment to be made. Often I found that it's the inability of the developer to be able to adapt to the circumstances in the build process, and that's caused the abandonment of certain issues. And again, we've mentioned it already, lack of natural resources, which results in an increased reliance on expensive imports. And then again, it's the importation of too much expensive expertise when Africa can be capable of managing things themselves. So projects in Africa fail, well, not only because of mismanagement, but also because of the sheer complexity. Specifically, projects fail because of lack of competency or knowledge in project management, and also because of corruption, poor policy planning and implementation and their complex context. The intention of projects is to improve African life for all, and a balance must be found to prevent abandonment and to eradicate the thorny issue of corruption. Again, just before I conclude, Africa, it works and it's in the face of many unknowns, where success and failure are not binary issues. Project implementers have to learn to think outside the box and to learn from failure in order to succeed more often. I was once addressed, or I once read, that Africa as a continent is too big to follow one script, and I think that's an important lesson to learn. Alistair, thank you.
Okay, so when looking at the stages of project management, then the Project Management Institute, quite a well-known project management body, sets out the five particular stages. Firstly, conception, initiation, planning, execution, performance and monitoring, project close. And they won't be a surprise, of course. In fact, they've been mentioned previously today. But we're going to look at each of those stages and provide some our thoughts on good practice. Before we do, Damien?
Yeah, I'm often looking at the situation in terms of what makes a good project manager, what makes good project management. And we talked to the two instances of reactive and proactive. You can see here on the slides, in reactive, we talk to a situation in which we cannot or do not plan ahead for problems or opportunities. And simply put, we react as problems or opportunities happen. Now, it's not always easy to be in a non-reactive situation, and we all want to be in proactive. And the proactive situation is that one where we plan ahead to manage or avoid our problems. Well, we must know what our problems are. We must be able to take cognizance of them. And in doing so, we take control of the process and build in time to properly consider and manage issues. If I may just run a little bit, Alistair, if that's okay. Obviously executing plans to achieve project objectives is important. The opposite of proactive is reactive. Characteristics of reactive project managers are they manage the project without a plan or don't follow the plan. They have a feeling of not being in control of their project all the time. And time is spent firefighting, resulting in reacting to present issues as opposed to predetermined project success criteria. I often comment to people that being hardworking and committed is not an excuse for being reactive, and you should all time try to be proactive, and that's where we want to sit with it all. And there's all the positives for a project manager in developing people skills, managing cost, scope and schedules and core responsibilities. They are what the project manager should do, and those are what the objectives ought to be. And in doing so, we'll avoid the Armageddon of arbitration and the lengthy disputes which tie up money and take us into this situation whereby we end up with tribunals with 3 tribunal members, and it's set in a different country, and it causes problems immediately in terms of costs, etc. So, you know, proactive project management as a whole has so many benefits to the work in Africa. I think one of the big issues for me, and Alistair may pick up on it, is obviously the levels of communication and the strong relationships that you must have with your stakeholders. You know, technical knowledge is very important, but it's not enough to manage a project successfully. You know, at times, conflict is unavoidable in project management, but being transparent, managing that with your stakeholders, communicating with the stakeholders, managing risk effectively, you know, it's an important element of project management in Africa. We talk to the other stages when we talk to monitoring projects and being aware that projects don't always happen according to the plan, and they don't, and it's the ability to change and the ability to recognise and address issues as and when they arrive. You know, we may deviate the reality from the plan, but we shouldn't, as good project managers, we shouldn't look to blame others, we should look to find the solutions. That is a positive step for stakeholders to see. So with clear, transparent communications, we'll get the help from the stakeholders because we'll be doing the project, we will be proactive in the project and we'll be dealing with the issues. So in short, Alistair, proactive project management's focus is on the solution, while reactive project managers focus on the problem, and we've got to look to change that to make the best of the work in Africa.
Absolutely, and it's a very holistic process, as you say. It's so multifaceted, isn't it? It's an incredibly important skill, being a project manager, and we're seeing a lot of contracts coming through now that are embracing proactive project management, such as the NEC form as well. So it's got to be good for projects and good for construction. And so we move on to each of the stages of construction. And first of all, I mean, it starts right from conception and then initiation. And Damien, you just mentioned engagement of stakeholders, and it's absolutely paramount at this stage. Preparing a case and feasibility study, of course, being able to define the project, at least at a broad level, and also defining the purposes of the project, scope, and key deliverables too, because after all, if you know what your key deliverables are, you can manage accordingly. Stage 2, this is it, we're now into the definition and planning stage of a project. And it goes without saying that defining a scope, setting a realistic budget with risks and contingencies adequately included is incredibly important. And many of the disputes that we see are due to a failure to properly define the scope or set realistic budgets at this stage. Then being able to break down the project into WBS, work breakdown structures, and into key activities which can be used as project data points for managing the project during construction. And then we're all familiar with Gantt charts, resource schedules, logic programs. We're all familiar with Primavera and Asta and various software that's out there, but actually defining a schedule which is realistic, first and foremost, but which is at a sufficient level to be able to actively manage the project. So it's not too detailed, but it's not too brief. It's sensibly logic linked, and it's properly logic linked as well. And actually, in some projects, resource loaded as well. So that then it becomes a very important tool for managing the project. And then we've mentioned the communication plan. And really having a definitive plan as to types of document that are going to be produced, who they're going to go to, who owns those documents, how it's circulated, and then who the documents go to. I think it's absolutely important to a project. And risk management, Mushtaq dealt with risk in terms of contractual and legal risk earlier, but having a was recognised in form of a risk management plan with owners of that risk is incredibly important to the project. Damien.
Yeah, just picking on what you say there, Alistair, as well. I mean, obviously, effective project management and to some extent, obviously, project controls, which is a whole different area to talk about. But obviously, when we do talk to resources in the African context, we need to be aware of the issues or the variables in productivity and the hierarchy of the issues which will affect productivity and how they should be reflected. We shouldn't just ignore them. We should obviously factor them in under effective project management. And that allows us, with status and tracking effective management tools, to focus on critical items. Well, we always have a critical path on programs, but there are other ways of looking at items. There are obviously milestone stages, as we talked to in the separate section. But if we look at productivity levels and output levels, it's we often find in the type of work that we're involved in is that output levels are only checked really at the end, and that's when we are trying to retrospectively determine what went wrong. But effective management tools include effective management and monitoring of outputs achieved on a site and recognizing when those outputs change and the productivity changes. Yes, with the KPIs, we can look at benchmarking a project by the sort of triumvirate of time, cost and quality, and look at the important milestone stages. And we should look to do that because there are issues to be managed in respect of stakeholders and quality issues and time and cost controls. In terms of quality, always an important issue. The effective tools in the sort of to manage quality come from the effective project manager, and that should be driven very much from the project manager in terms of benchmarking milestones and even in terms of actual how payments are released. When we look at forecasts, obviously we've got to look at a recognition of the issues which affect resource management, and I've talked to that in respect of productivity as well. The scarcity of products in terms of the level of inputs that are required. We talked to importation of resources, and we saw that during the recent years of the pandemic, that it's not only importation of resources for the build of the brickwork and the blockwork and the roof tiles, etc. It's the technological aspects in respect of the large scale plant that is required on certain projects and how the spares are brought to site, how the commissioning engineer is brought to site. And we've seen those massive difficulties over the last 12 months during the pandemic situation. Importantly, again, we come back to the reasonable approach to these, allowing communication with stakeholders and managing the expectations and managing the investment, allowing our stakeholders to feel comfortable with everything. And I think, as the development process to monitor and manage events is key. A problem identified early, and that's the proactive project manager, is a problem that can be managed. And I think here, we talk to the very fact that we avoid the reaction, we allow communication and problem solving of root causes, we look to recognise it as quick as we can. And yes, and that's very easy in a sort of utopian society, but being proactive and interactive and in the project and communicating and using what I've called here the toolbox of project management, the three-pronged approach to time, cost and quality, will assist greatly. And it's the recognition of the key items, which is part of project success, but it's their application to the cultural, socio-economic environment in Africa, which has its own uniqueness, and it's a uniqueness that we ought to engender and enjoy as well. So,
Damien, you're going to pick this one up?
I'll pick this one up. Yeah, thanks, Alistair. Measuring performance is equally important. If you know how you're performing, you can make changes to improve future performance, and that lends itself to the mutual objectives of stakeholders and the contractor alike. The quality deliverables in respect of where we sit, where we are with the project, what stages we're at, are we on time, are we on budget, but importantly, are we managing the quality to give the product that's required? I mean, we've seen it 1,000 times. The money that's required to make the finishes look good on a project has been spent in the demolition or the groundworks or the substructure. The most important part of the project is delivering a building which is to the satisfaction of the stakeholders. So quality deliverables are essentially important, and that comes from our efforts in managing those processes, cost tracking and dealing with performance. Measuring performance is essentially important, and we've got to look at the schedule. We've got to say that project management success is determined by whether or not you keep to the original timeline. That's an important part of it. It's equally determined by how you react when a delaying event occurs. Quality, well, the end of a project phase is a good time for a quality review, but it's built in stages before that. Cost, we talk to that consistently in terms of numbers and not going over budget. If the budget is correctly calculated and it's reflective of the issues that you may face in the African continent, then it won't be so much of a shock in terms of some of the issues that people will start to allege as the basis of the cost in the future. There are foreseeable issues in respect of cost that ought to be dealt with. Stakeholder satisfaction is another issue for me in terms of the 5 stages and the control, the performance of the control. And it's not just controlling downwards, it's controlling vertically to the stakeholder, keeping them aware, keeping the communication open, being transparent about the issues and dealing with the issues together, protecting people's money, and at least making them feel like they're protecting their money is being protected. So if we go back to the project manager, he needs to have not just technical competence and intelligence and professional background, he needs to almost have an emotional intelligence to him of how he can deal with people to manage upwards, downwards, around him to the benefit of the overall project. And performance, obviously performance to the business case. As soon as projects are performing, then investment continues. And I think we've seen that the world over, and we will see it the world over. So the best case for investment in Africa is the performance on projects that have been completed.
Absolutely. And finally, project close. And this is an incredibly important part of the project management process. And really it's something that needs to be planned from day one almost. But coming up to project close is a good time to review the obligations of the contract for handover and acceptance. It's a good time to also check what's been built against the scope and what still has to be done to get the project over the line. And I think, as Damon just mentioned, really, I mean, communication with those involved in the process is key. Transparency is key as well, I think, to that process, and making sure there's an honesty in getting what needs to be done complete and the project over the line. It can often be the most fraught stage of a project, getting acceptance, particularly where you have performance obligations as well. And I think it's something that a stage in the process that's quite often underestimated and actually must, in my view, be considered at a very early stage and planned for properly. And finally, I'm not sure how we're doing for time, whether we've had time for some case studies. Shivani?
I don't think we do, unfortunately.
Oh, okay. Well, maybe next time. But thank you all very much for listening to us this afternoon. Thank you.
Thank you very much.
Thank you so much, Alistair, Thierry, and Damien. Sorry about the time. I would now like to introduce Ilham Kaburi, who is an associate at Hogan Lovells Dubai office in our international arbitration team, who shall be discussing dispute avoidance.
Thank you, Shivani. So, as Shivani introduced me, I'm a disputes lawyer, and early on, Angus introduced himself as a disputes lawyer as well. Angus is a partner in our construction and engineering team. Shivani, can you share the slides for my presentation, please?
Yeah, cool.
Okay. So, essentially, Angus and I are the lawyers you don't want to be seeing, because if you're seeing us, it means you're having problems. It means you are at war, and war is expensive. So today we're looking into how not to sit down with either Angus or I, or Angus and I. We're speaking about how to avoid disputes. So as Damien said, conflicts and disagreements in construction projects are unavoidable. What I will be looking at here is how you can try to prevent conflicts and disagreements arising in the context of a construction project escalating into formal disputes. So we have four main tips in that regard that pretty much relate to what Damien and Alistair called proactive project management. So first, invest upfront, and I will shortly tell you what I mean by that. Second, records, and we cannot overstate the importance of records. And third, not only have your papers, but have them in order. Fourth, manage your stakeholders and manage any interfaces. So invest upfront. Before I get into that, before I get into what we mean by invest upfront, although today is not about what you should have in your contract, but rather what you should do when executing your contract. risk allocation is key. Risk allocation in the contract is the first step to avoid dispute, but that's something Mushtaq touched upon, and that's something I don't have time to get into in much detail. So let me get on with invest upfront. What is that? So according to Arcade's Global Construction Report of 2019, the number one, and I repeat, the number one cause of construction disputes was parties' failure to understand and or comply with contractual obligations. So investing upfront is basically making sure that first your project team understands the key contractual provisions, the obligations, the requirements, and the procedures to establish entitlement, for example, EOTs, variations. Ensure your project team understand the contract, but also ensure you design mechanism for the implementation of those contractual procedures, mechanisms that are simple, mechanisms that actually work and that won't be ignored. Keep it short and keep it simple. And third, ensure that your team complies with the contract, complies with the condition of the contract, with those procedures and those mechanisms you have in place. Policing the compliance is really key. You need to have procedures, but you need to comply with them. So that's the first advice. Advice number one is invest upfront. Advice number two, records, records, records. And again, we cannot overstate the importance of records. Appropriate records should be kept at all stages of the construction project to assist with first the effective project management, the effective management of the projects, and that is the primary purpose to help monitor costs, to help monitor progress, to help monitor the quality of a project. Second, records are required for the substantiation of claims, and they're also helpful for defending claims. And third, in the event of formal dispute arise and proceedings commence, and it goes all the way, records will be used as evidence before tribunal, and that is why they are also important. Contractors are often advised to keep detailed record. Not only that's recommended, but that's also elevated into contractual obligation. For example, in most forms, and for example, the FIDIC Red Book requires records to be kept for health and safety, the contractor personnel and equipment, measurement, evaluation, payment, but also the contractor's claims. Contemporary records are key in substantiating and in defending claims. Let's look, for example, at delay claims. You're a contractor, you seeking relief, be it cost relief or time relief in respect of delay. Your delay claim will relate to events that have occurred either in the recent or the more distant, relatively distant past. And it is only through the use of records collected at the time the delay events occurred that you will ascertain what happened and whether there is an entitlement. The absence of records often leads to disagreement as to what happened, because the parties will have different recollections as to what actually happened. And that increases the risk of a disagreement escalating into a formal dispute. Finally, records are key as evidence before tribunal. Disputes are often determined by retrospectively looking at the available records that were kept during the course of the project. Arbitral tribunals in general, be it in litigation or arbitration, are likely to give more credence to contemporary records than to factual or expert witness evidence, or to documents that were produced well after the related events and with a claim or dispute in mind. Essentially, records are knowledge, and we all know knowledge is power. From the lawyer's perspective, records are very important because first memories fade, and then, I don't like to say that, but people lie. Contemporary records are the most reliable, regardless of their completeness and accuracy, regardless of however prone they can be to multiple and competing interpretation, and regardless of the fact that they reflect the knowledge of the author. The record is the record. It is what was said, and it is probably what was thought at the time the event happened. So advice one, invest upfront. Advice two, records, records, records. And advice three, it's good to have papers, but have them in order. So document management is really key. Not only records must be kept, but good document management system should be in place to allow efficient storage and retrieval of those records. And finally, the last advice in terms of how to try to avoid disputes is the effective management of stakeholders and of interfaces, and that's something Damien and Alistair spoke about as well. So there are a lot of stakeholders on a construction project: the employer, the contractor, the subbies, the JV partners, etc., etc. The design consultant. Effective management of all those stakeholders is paramount. It will involve, among other things, for example, the effective management of the client. Understanding the client's objective, communicating issues and problems early on is fundamental, for example. It will involve the effective management of the contractor, the design consultant, making sure you regularly assess progress on the works, on the costs incurred, make sure there is effective communication. In addition to effective management of all stakeholders on more complex construction projects, where, for example, the owner does not rely on a single EPC contractor, and there is strong interface between the works of the different contractors on the project, interface management expertise is paramount. So interface, for those not familiar with what we call interface management. Interface occurs where different contractors are engaged on the same project and the different streams of work interact or connect in a way or the other. Classic example, design and construction, linked, connected. Interface risk refers to the risk created by the failure to effectively manage those multiple stakeholders. And interface management is the management of that risk. It's all about making sure there is communication between those stakeholders to minimize that risk. Make sure that there is visibility between the different streams of work that are connected. And this can be done in the contract through the inclusion of collaboration and cooperation clauses, or through specific mechanism in place in the implementation of the contract. So, for example, bi-monthly, meetings with all contractors and the employer, correspondence reports, etc. So that's the first part of the presentation: how to avoid construction disputes or disagreements escalating into disputes. Invest upfront, records, have your papers in order, and manage your stakeholders. But what if the disagreement is not resolved? What if you are facing a formal dispute? What do you do? So before doing anything, just don't do anything and stop and think. Before becoming, heavily involved in disputes, sit down and think of your priorities, your goal, your objectives. It's far too easy sometimes to get lost in the heat of the battle and lose sight of what's actually important. So stop and think, grapple with the situation, identify your goals, identify your priorities, identify your risk, legal, commercial, and do all of that to try to formulate a strategy. So the strategy will cover a number of things. It will cover the examination of the key facts. On the examination of the key facts, do not accept facts as reported or presented. Review the papers, be neutral and objective. Try to keep causes to effect. Look at those facts the way a tribunal will look at them. So examine facts, make an legal analysis of the claims, be it the claims submitted or the claims you're trying to defend, maybe with the assistance of external counsel if necessary. Assess your commercial interest and the relationship, assess how the dispute will impact your organization and, more importantly, the construction project. And review the potential dispute resolution processes available to you, the available contractual remedies as well. And again, get your papers in order. That strategy won't be set in stone. That's something you can go back to and amend as required. Basically, stop and think at regular intervals and follow follow how the situation is evolving. By making that assessment, by doing the stop and think and formulating the strategy, you will have visibility. You will have visibility on the choices that are open to you. there is always choice, and the circumstances will dictate whether you will proceed with using contractual remedies, for example, notices, suspension, worse, termination, or maybe using security. Maybe it is time to call a bond, or proceeding with a dispute resolution process available under the contract. So stop and think, formulate your strategy, and then make a call. But always, always hope for the best and expect and prepare for the worst. Be prepared to go the distance. Dispel any thought that because your cause is just, you will win. Recognize, and that goes back to records, and I cannot overstate how important they are. Recognize that you can only ever win with evidence, and plan and work for a final hearing on the basis it will happen. This will not only help you identify very early on the weaknesses and gaps in your case or in your evidence and do something about them, but it will also show the other side that you're serious, that you're ready to go all the way if you have to. So on these words, hope for the best and plan for the worst, I will conclude my presentation. Over to you, Shivani.
Thank you so much, Ellen, for such a clear and strategic presentation. This now brings us on to our second panel event of the afternoon, and this will be hosted by Nathan Sell, who's a partner in our London office in our international arbitration team. He will be joined by Yakuba Lee from Group 1 in South Africa, Samuel Bayen from Legal Line Partners in Rwanda, John Malutu from Aurora and Company Advocates in Kenya, and Nsima Irene from Anguilla Busiku & Co in Uganda. This panel shall discuss the complexity surrounding dispute resolution in East Africa. So over to you, Nathan.
Thanks very much, Shivani. Conscious of time, I'm going to hand over to Yakub Ali, an advocate in South Africa, who's going to talk to us about enforcement of arbitration awards in East Africa. Particularly focusing on the New York Convention and talking about some of the difficulties, particularly in the area of public policy. So over to you, Jakob.
Thank you very much for that, Nathan. So as Nathan says, I'm here to talk to you about enforcement of foreign arbitral awards in East Africa. Of course, it's all well and good to talk about arbitrations and arbitration processes, but without being able to enforce those awards, of course, they are not worth the paper they're written on. There's been a great shift in the world over the last 50 or 60 years in the field of arbitration, and this is in no small part due to the New York Convention, which was adopted in 1958. It's now come to be known simply as the New York Convention, but the actual full name is the recognition of the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. It has been described as the most successful treaty in the sphere of private international law. It's been adopted by over 80% of countries worldwide, and I will return to what percentage of Africa's accession and participation in that is. But I think it helpful first to run through briefly what the convention is about before I do so. So what the aim of the convention is there are really two principal objectives to that. And the first is to recognize and enforce foreign arbitral awards. And the second is to uphold valid arbitration agreements. So where parties agree upon to have their dispute resolved by way of arbitration, a country that has acceded to the convention must recognize that the parties must have their dispute resolved by way of arbitration rather than litigation. There are then moving on the convention, there are limited grounds on which enforcement can be resisted, and those are divided into two categories. The first appears in Article 5.1, and that is where the unsuccessful party can challenge execution essentially on the basis of violations of rights to due process, such as incapacity, inability to present your case, and the like. I'm not going to run through, because of the time constraints, the individual bases on which an unsuccessful party is allowed to challenge the execution of a award, recognition and execution. Then we get to Article 5.2, which doesn't relate necessarily to the interests of the losing party, but it allows the courts of a contracting state to refuse to enforce or recognize the enforcement in a foreign arbitral award on the basis of the grounds that it would breach its own public policy. So that's the difference between the two grounds of exception. Now, turning then to Africa's participation in the New York Convention, there's been widespread accession to the New York Convention, such that 42 out of 54 African states in total have acceded to the New York Convention. The most recent was Malawi, which acceded to the convention just last month. That was March 2021. There are only 3 East African countries that have not acceded to the convention thus far, and that's Eritrea, Somalia, and South Sudan. The list of countries that have acceded in East Africa is a very extensive one. It's Kenya, Uganda, Tanzania, Ethiopia, Madagascar, Mozambique, Seychelles, Mauritius, Comores, amongst others, but there are a whole list other than the 3 that I mentioned. Somalia, incidentally, have been in negotiations to accede also, so that's a space to look out for. Now, turning then to what the principal thrust of my discussion with all of you today is, and that is the public policy exception. Now, I think we're all familiar with the now 200-year-old, almost 200-year-old description of public policy by Barrow J, in which he described public policy as an unruly horse. Which when you get astride, you never know where it will carry you. And that is something that continues to, of course, ring true to this day. So what is public policy? Briefly, it pertains to the values of a society. It's matters of such fundamental importance that a state or the courts hold that parties cannot circumvent. So they must, in the view of the state or the courts, violate the most basic notions of morality and justice to that particular society. Now, insofar as trends in East Africa go, happily, the shift is towards the narrow interpretation of international public policy, and that is the principle of international comity, where the principles of international law are respected over the public policy of a country. So where a foreign state, the laws of a foreign state, in effect, are given effect to other than when it's considered repugnant to local public policy to such a degree that the courts will not overlook them. Now, there is one particularly interesting development in East Africa that's on the go at the moment, and Mushtaq from BLC Roberts discussed the case. He didn't mention what the case was, but he discussed the public policy exception effectively as a risk that faces projects. And that case, as Mushtaq indicates, was argued before the Judicial Committee of the Privy Council on 21 and 22 January of this year, and judgment is awaited in that matter. It's the State Trading Corporation versus Betamax. And it's one that I would urge all of you to look out for because it's an interesting case on public policy. In essence, what happened there is the Mauritian Supreme Court, 3 judges of the Mauritian Supreme Court, set aside an award of the Singapore International Arbitration Center on the grounds that it violated Mauritian public policy. Now, what is interesting about that is the arbitrator had made a finding that the contract itself did not violate the Mauritian Public Procurement Act. The Supreme Court, in fact, went behind that award and effectively reviewed that award. Now, whether they were correct in doing so is something the Privy Council will weigh in. My own sense of it is I don't believe that they ought to have went that far and overturned the decision itself. It was an application for the enforcement of a foreign arbitral award brought by Betamax against the Mauritian State Trading Corporation. And there was a collateral challenge by the State Trading Corporation to set that aside. Now, interestingly, under the new Mauritian Arbitration Act, International Arbitration Act, this is the very, very first time that they've refused to enforce a foreign arbitral award. So it is really a cutting-edge development in terms of public policy exceptions in East Africa. Now that case, I had mentioned that the Supreme Court had set aside the award of the arbitrator. Now contrast that with the case, and I'm going to conclude simply with this because I understand we are pushed for time. Contrast this with the case, the famous case of Soleimani versus Soleimani, where there were two Jewish Iranians who brothers, a brother, father, and a son, who fell into dispute. And they are resolved to have their dispute adjudicated by the Beth Din, a Jewish religious body. And the Beth Din they made a finding that the contract was one of smuggling, where they were smuggling carpets out of Iran in contravention of the Iranian revenue and exchange control laws. But that was inconsequential under Jewish law, and therefore the agreement was not invalid. When application was made to enforce that arbitration award in the English courts, what the English courts did was accept the arbitrator's award in its terms and saying, well, the arbitrator made a finding that the agreement was unlawful, it was illegal. But it's repugnant to public policy because to enforce the award would be to sanction the contravention of the laws of a foreign state. And you can easily see in that instance why the public policy exception could be properly invoked. In the instance of State Trading Corporation versus Betamax, there was a reversal of the decision of the arbitrator. And that is what I say is an interesting, it's an interesting sort of difference between those cases. And it will be really interesting to see what the Privy Council, the Judicial Committee of the Privy Council does with that. So the caution then I would leave you with on that is that in the field of public procurement in East Africa, pay particular attention to compliance with local public procurement laws. That is essential. You cannot unscramble the egg when it's too late, but at the beginning, it's important to take proper legal advice and understand the nature of the beast, and that is public procurement in public projects. So that is really what I wish to share with you, and thank you. Thank you for your time. Thank you, Nathan.
Thank you so much, Jakob. That's really interesting, particularly given the importance of procurement legislation when it comes to infrastructure projects. I'd now like to ask John Bluto, a partner at leading Kenyan law firm Arara & Co., to now talk about some of the practicalities of resolving disputes in the current digital environment, and what are the pros and the cons, as it were, of resolving your dispute online. So over to you, John.
Thanks, Nathan. So yes, I think we are all alive to the context within which we find ourselves in the world, which is the COVID-19 pandemic. And governments throughout the world have deployed different measures to mitigate the spread of the virus, most of which inevitably end up curtailing free movement of people. And therefore, for instance, if you wanted to have a hearing in a certain city, you might not be able to do so. Kenyan example right now is that the 5 counties, including Nairobi and the surrounding counties, are actually in what is called a red zone lockdown, having been declared as disease-infested counties. So practically, an example is if I had a witness say Mombasa, which are the 2 other major cities in Kenya, those witnesses are able to come and have the hearing take place in Nairobi. So yes, that's a practical reality which we find ourselves in. And in reaction to that, governments, including the Kenyan government, have issued guidelines and protocols which we are all required to observe. In Kenya, on the 15th of March 2020, the Chief Justice actually directed that there should be a mass scaling down of all court operations, and directed further that all physical hearings be suspended and all courts undertake hearings through virtual functions. Subsequently, or rather, before I go to what has happened after that, perhaps just to take a step back. And it was actually something that is contemplated in Kenyan law, that hearings can take place virtually. There's express provision both in the Evidence Act as well as in the Civil Procedure Act. And a decision which I would like to highlight is a case that was determined in 2019, which is before, actually early, mid-2019 in the month of March, the case of Jubilee Holdings versus Bupa Insurance, a case which I played a role in. And in that case, the defendant actually made an application for video link evidence to be taken in respect of one of the witnesses who are based in the UK. Our instructions were to oppose that application for various reasons, but upon considering the matter, the court actually found that the law allows for video link evidence to be taken. So this is before the pandemic actually broke out in later 2019. In some, the court found that issues of witness credibility, which was one of our concerns, could actually be sufficiently addressed through cross-examination. You could cross-examine via virtual or video link just as well as you could cross-examine in court. And therefore, the court found that any issues to do with whether the witness was being honest or not could be as effectively achieved through virtual means as through a physical hearing. The other issue which we had raised concern was about technological failures. With video links and poor connectivity, sometimes you can lose the flow of the process. But the court found that the party should take steps to ensure that the video link is fully functional and that the application would not be disallowed merely because of speculation as to whether or not it would work. You would only find out whether it works once you actually try. And lastly, the court found that this is a cost-saving imperative which was taken into account, given that under the law in Kenya, justice should be free, not free, but affordable and accessible to all people. And she found that since the witness in this case was based in the UK, the saving of the need of the witness to travel all the way to Kenya just to testify when it could be done via video link would mean litigation would be more cost effective. And for those reasons, she allowed the application and the witness was able to testify via video link. That was before the pandemic, just to demonstrate that even before the pandemic, there was provision for conducting proceedings virtually. But of course, the pandemic has been a major catalyst in that, whereas before it was the exception, it is now what is called the new norm. All courts are handling their matters electronically. All filings are being done electronically. And really, as I said, it's now the new norm rather than the exception for a matter to proceed virtually. From the arbitration front, there have been guidance notes issued both by the Chartered Institute of Arbitrators as well as the African Arbitration Academy, which have issued protocols of guidance on virtual conduct of arbitrations virtually. The key thing to note is that in line with the principle of party autonomy in arbitrations, it is very important, in fact necessary, for both parties to sign off on the means through which the hearing will be conducted, if virtual. This will then avoid any applications for the setting aside of the award subsequently if both parties actually agree to it. The protocols are quite detailed. I don't think I have enough time with the time allocated to me to go through them, but they are quite useful. In one arbitration that I did recently, I found that mixing and matching various items from both the Chartered Institute guidelines as well as the Africa Arbitration Academy guidelines was then able to tailor fit out specific arbitration, and we were able to proceed quite smoothly virtually. So in terms of the pros, I think the most eminent one is obviously saving of costs. Witness traveling to and fro is now known, and even the parties, of course, of the advocates, traveling has been reduced, travel expenses rather has been reduced greatly. There's also the ease with which the hearings are actually conducted. Documents which are stored electronically, are easier accessible, and by virtual means of sharing screen, all of you are able to seamlessly follow the proceedings that's it, it's all set up well. The cons that you might experience are that in experience with, especially in Africa, I must say, not all quarters are fully developed or advanced or even have internet connection. So you might find, because of remote locations, one might not be able to really enjoy the same virtual environment as perhaps someone in a city such as perhaps Nairobi or Kampala or any of the other major cities in East Africa. The other is the cybersecurity concerns. I think we all are aware of the increase in the cyber, people, the hackers, the Zoom bombers or maybe just anyone who's unauthorized who somehow finds a way into the session. That obviously is one of the downfalls of having a virtual session, which can obviously be mitigated with enhancing security features, either through password being issued and the like. There are also difficulties depending with the difference in time zones. Sometimes beginning an arbitration at 8 o'clock in Nairobi would mean people in other parts of the world would be basically waking up in odd hours of the night. So because of that, the arbitrator would have to be time conscious of the different time zones. Credibility concerns, it still remains a live issue. Advocates prefer, I find, if there's a credibility concern with a witness, they would rather cross-examine that witness in open court physically rather than virtually. I suppose the whole courtroom scenario, the live room scenario, is one supposes they're able to bring out truth better than through virtual means. And of course, a corollary to that is that one sometimes apprehends that if a witness is in a virtual setup, there might be coaching of the witness, and literally the free space which a courtroom or an arbitration room affords is missing. But obviously, there are ways of mitigating that. I think there's a 360-degree camera, which most arbitrators are insisting on having, so that they have a full view of what the witness and the advocate is doing. So with that, I think just to the point to note is that yes, this is a new norm. It's a way that litigation and arbitrations are being conducted, and with party cooperation, you can actually proceed rather smoothly through virtual means as you would through a physical hearing.
Fantastic. Thank you, John, for that insightful presentation and as to what is becoming the new norm, as well as saving costs. I think we're also seeing the an increasingly environmentally conscious clients and lawyers wanting to also save on the costs, not just the cost of the affairs, but also their carbon footprint as well. So thank you for your helpful summary, particularly of those very useful guidelines from the AAA and the Chartered Institute, as well as those practical protections like 360-degree cameras that we can use to ensure that we get to the truth. I'd now like to change tack and hand over to Samuel Bayene to give us the perspective from Rwanda, and in particular, Samuel's going to take a more holistic view on what are some of the common areas that give rise to disputes in the context of projects in East Africa. So without further ado, I'll hand over to Samuel.
Yes, thank you very much, Nathan. Thank you for the introduction. It's a pleasure to be part of the panel. We are going to discuss about common issues arising from construction claim and dispute in East Africa. Basically, construction dispute in the region follow the classic scheme. I mean, you have a dispute related to site safety condition, change in works and error, unforeseen site conditions, negligent supervision. But those I feel personally like they are quite repetitive. A dispute related to delay, payment, and defect. Can be defect based on the design or the construction itself. Now, Going back to the common we have just picked few considering the time constraint. So the first issue we are going to discuss is the issue of management of a dispute at early stage. In fact, as you know, dispute in construction often start out as small misunderstanding, small disagreement, and finally reach to something with huge implication if not efficiently managed. So the point being here that many disputes in construction have escalated because parties have failed to implement the appropriate tools in terms of dispute management, and therefore to avoid escalation. So considering the specificity of construction projects in some region, I think it's always on parties' interest to adopt avoidance strategies during the project planning, the pre-construction phase, the construction phase, and even in the project close. The classic mechanism used here is generally when there's a disagreement between parties. The classic mean usually used is negotiation, which outcome is often compromised from the outset, and this is due to various factors. For instance, you have the fact that there's many stakeholders having different expectations, and also sometimes the fact that the people involved in negotiation do not have the power to take decision in a timely manner, and this really affects the negotiation process itself. So there is a need to have another approach, and for instance, there is a fantastic tool which has been recently adopted by the FIDIC. It's the Dispute Avoidance Board, which I feel like it will be very useful in East Africa context, considering the fact that we have many projects of a certain size. But the reality is that, of course, that dispute avoidance board are not widely used yet. Perhaps this is also due to the fact that the mechanism itself is quite recent. It has been introduced in 2017. Another trend we also see generally is the assistance provided by the professional bodies, Institute of Engineers, Institute of Architects, which provide an assistance to their members in order to resolve their dispute at early stage, including in the context of a project. And this approach has demonstrated its efficiency as the dispute is managed by the peers. And I'm sure my friend Papias Kazawaji, who was intervened earlier and who has served as the president of Institute of Engineers of Rwanda, would agree with me on that point. Perhaps the second issue is the issue of the relevance of the dispute mechanism chosen by parties in the contract, and I will specifically apply this to adjudication. In fact, adjudication in East Africa is not yet, it's by itself not yet codified. This is to mean that adjudication mostly relies on party willingness to participate on the process or to comply with the adjudicator decision, and this has really hindered the full attainment of potential of adjudication as dispute resolution mean in the region. The simplest way, of course, is perhaps to not include adjudication in the contract, but you still have many construction contract in the region where parties have provided adjudication, and therefore in a situation where the losing party refuses to comply with the adjudicator decision, then the other party, the party having the adjudicator decision on its favor, will be likely to face enforceability challenges. The technique in that case usually applied is to file a civil claim in court, against the losing party, using the decision of the adjudicator as the base of the claim. But in that case, you also see that the utility and the rationale behind adjudication, which is to save time and to have a quick and expedient decision, has already been lost. So there's a real necessity for East African countries to formalize the recognition of adjudication at the same level as arbitration and mediation and conciliation. I know in Kenya, there is an adjudication bill on the pipe. The discussion is also on the table in other countries, like in Rwanda, where the discussion is on the table in Rwanda and in Tanzania as well. The idea of a court-ordered adjudication has been even put on the table, but this, especially in Kenya, but this proposal has been, I think it has been rejected by the parliament. But my personal feeling is that there's still a room to reach a consensus on that point. Perhaps the last issue would be the issue of evidence production during the litigation. I know, of course, there might be, one of the reasons might be the technical challenges, and I'm glad that John Baluto has discussed about that. Because, of course, even in the context of virtual hearing, and you have to submit evidence, it might be not easy if you have a huge volume of documentation to submit. But I would more like to focus on one point, which is the way the project are managed, and the issue of evidence production may also come from the way projects are managed. And the reality is that many projects are not managed in an appropriate way in terms of project documenting and recording. And as you know, in construction, poor records leads to poor reporting and therefore badly critical design paths. And these usually have a big impact during the litigation phase, because in one hand, you have party who cannot optimally ensure clarity to its argument. And in the other hand, you have the tribunal who does not have all the relevant information to take in order to take a strong decision. So parties should be very careful on documenting their interactions by program records, progress record, resource record, and even cost record. Good recording is important, as it significantly assists the success of parties in case in litigation, and even potentially avoid the dispute itself. So these are the few thoughts I wanted to share with you, and I hope it was useful. Thank you very much.
Thank you so much, Samuel. That was incredibly helpful. And picking up on the point that Samuel was making about those escalating dispute resolution clauses, I'd now like to hand over to Irene Nishima, who is an advocate and legal consultant at Agwalia Bisuko and Co Advocates in Uganda, to give us a perspective on alternative dispute resolution in the context of East African projects. So Irene, over to you.
Thank you. Greetings, everybody from Uganda, the Pearl of Africa. I'll be talking about the different alternative dispute resolution mechanisms in the resolution of construction disputes in East Africa. Alternative dispute resolution, normally called ADR, refers to different means of resolving a dispute other than reverting to litigation in the courts of law. The construction industry is well known to have many disputes. A construction dispute arises where one party to a contract puts up a claim, either for extension of time, additional costs, or other entitlement, and is disputed by the other, either on the facts or on the quantum. Traditionally, parties would litigate this in the courts of law but over time, ADR has become the preferred means of resolving disputes because of its advantages. Number one, ADR is swift, it is less costly, it maintains the relationships of the parties, it's confidential, and parties generally have control over the process. Construction contracts will usually have a dispute resolution clause, which is a very important aspect of the contract. And the resolution clause will usually specify the mechanism that will be resorted to in case of a dispute. Now, where there is a clause specifying a mechanism, parties are bound to follow that mechanism in the absence of consent by both parties to follow a different mechanism. I'll run through the different options that are available to the parties. Number one, we have negotiation. Parties themselves attempt to settle their dispute using a range of techniques, ranging from either concession, compromise, confrontation, or even coercion. The key thing about negotiation is that parties have autonomy over the process and the outcome, and negotiation can continue alongside other dispute resolution mechanisms. Then we have conciliation. It is similar to negotiation, but it is usually provided by law. For example, in Uganda, we have it provided by domestic legislation. A third-party conciliator mediates the dispute and proposes a solution to the parties. Then we also have mediation, which involves a third-party neutral mediator who also helps the parties to reach a mutually agreeable solution. The difference between mediation and conciliation is that in mediation, the parties have control over their solution, but in conciliation, the conciliator proposes different options as solutions. We also have expert determinations. This is where an independent third party who must be impartial acts as an expert in the field to settle the dispute. It is usually used for disputes of a technical nature, where the issue at hand is one of fact rather than law. It's particularly useful where the dispute turns on a point which is of a technical nature. Then parties can also employ what we call early neutral evaluation, where a neutral third party, usually a legally qualified person like an attorney, gives an opinion on the likely outcome at the trial as a basis for settlement discussions. The aim is to test the strength of the legal points in the case, and it is particularly useful where the dispute turns on a point of law. So expert determination is useful in matters of a technical nature, and early neutral evaluation is useful where the matter turns on a point of law. Then we have two other and the most important and commonly used methods of dispute resolution. Number one, we have adjudication before the DAB, the District Dispute Adjudication Board. Disputes are resolved by a third party, what we call an adjudicator, chosen by the parties under the contract, or this person may be appointed by an appointing authority. It is an informal process operating under strict timescales. In fact, a number of commonly used standard forms of contracts, like the FIDIC forms of contracts, usually contain adjudication clauses requiring adjudication as the first stage in the mechanism of dispute resolution prior to commencement of any arbitration proceedings or litigation in the courts of law. Municipal laws of East African states have adjudication proceedings regulated under their domestic legal regimes in form of adjudication guidelines by institutions undertaking adjudication in the construction disputes. For example, in Uganda, we have the adjudication guidelines issued by Uganda Institute of Professional Engineers, and Kenya also has adjudication proceedings which rely on the construction adjudication rules issued by the Chartered Institute of Arbitrators. Construction adjudicators are usually professionals from the construction industry, knowledgeable and experienced construction experts, and well-versed in the dispute resolution procedures. The proceedings are not like in ordinary litigation. There's no cross-examination, no formal evidence or lengthy legal arguments, and sometimes facts may be proved solely by documentary evidence. Once both sides have set out their sides of the dispute, the adjudicator helps them to reach a solution, and this must be usually within 28 days or a lesser time provided under the contract. Adjudication decisions are binding, but they can be revised through arbitration or court process. So adjudication does not finally determine the dispute, though in practice, adjudication decisions are usually accepted by the parties. Then the last method of dispute resolution other than litigation is arbitration. It is a non-judicial process for settlement of disputes where an independent, neutral third party, an arbitrator, makes a decision that is binding on the parties. The decision is called an arbitral award, as we all know. The arbitral award, the key thing about it is that it is enforceable. It is enforceable in the courts of law, like a court decree. So it has a force of an ordinary court judgment. States have legal regimes on both domestic and international commercial arbitration. There's also a regional mechanism at the East African Court of Justice, but we have to note that the East African Court of Justice only has jurisdiction over residents of the East African community. Once an arbitral award has been made, it is recognized and enforced at the domestic level of an individual state where enforcement is sought. An award must be registered and together with the arbitration agreement. An arbitration agreement can either be a clause in a contract or a separate agreement. I will not say much about the New York Convention, which has already been talked about. Most of the East African states are parties to the New York Convention. We have Burundi, Kenya, Uganda, and Rwanda. So an award holder can enforce the arbitral award in the 149 state parties to the New York Convention, and the reverse is true. Someone holding an award from any of the 149 state parties to the New York Convention can enforce their award in any of the East African state parties to the convention. Tanzania, on the other hand, is not a state party, but Tanzania has not ratified this convention, the New York Convention, but its domestic legal framework on arbitration is based on the UN CITRO model law, which takes into account the particular features and needs of international commercial arbitration. Thank you.
Thank you, Irene, for that whistle-stop tour of the various forms of alternative dispute resolution. Thank you very much to the distinguished panelists who have taken us through a range of hot topics in dispute resolution on East African projects. Hopefully, taking into account what the earlier speakers said, you will be able to try and resolve your disputes at an early stage, but if not, we've had some really useful guidance when it comes to the process for resolving disputes and then enforcement. So thank you very much.
Thank you so much, Nathan. And yes, just to echo you on what was such a fascinating panel discussion. I also want to thank all our attendees for your questions today. Due to time constraints, we're unable to have the Q&A today, but we're working with ACL about how to get your questions to the panelists and speakers and the answers back to you. Before I hand over to Sakai Nyambo from ACL for her closing remarks, I would like to extend a huge thank you today to all our speakers, panelists, ACL, and of course, all our attendees for your contributions today. So Sakai, over to you.
Hello all, thank you Shivani. As she rightly introduced me, my name is Sakai Nyambo. I'm one of the directors of the ACL, and I'm also an associate director with HKA. Unfortunately, we have come to the end of the East Africa sub-regional session. It's been a wonderful session. I have learned so much from all your jurisdictions. It's been really, really interesting. And in the interest of time, I am not going to tell you everything that I've learned because I've learned so much. So I just want to say thank you regarding your valuable contributions. I just wanted to say everything that we heard today was merely a taster of the snippet of construction law related issues that we as professionals regularly deal with in the region of East Africa. ACL will be hosting future events and producing publications which will enable us to address many of the issues that were discussed today. So if I'm aware that there are questions that were posted that we weren't able to get to in the interest of time, but if you didn't get a chance to post your questions, please feel free to still send us an email with your questions. You're more than welcome to do so at info@africaconstructionlaw.org, or simply email individual speakers if you have their contact details. Again, on behalf of the ACL, I'd like to say thank you to all of you, to the attendee speakers, but most specifically to our collaborating partners, Hogan Lovells, Aurora and Company, BLC Roberts, Anguilla Boseku, Legal Line, and FTI. And not just the organizations themselves, but also your marketing teams, because they have worked very hard. So we just want to say thank you for all your hard work and all your efforts. I'd like to remind everyone that today's session was part of the ACL virtual conference launch, which commenced on Friday, but will continue throughout the other sub-regions until the 15th of April. We appreciate that some of you have organizations that have projects and offices across the continent and may want to know what other ACL sessions are happening within the various sub-regions. We would like to encourage you to go to www.africaconstructionlaw.org/conference to tune in to the other sessions that are going on in the other sub-regions. It is not too late to register, so please go ahead. I'd like to finish off by reminding everyone that the ACL is in fact the global platform for construction law and practice in Africa, and is the most appropriate and relevant forum for lawyers, dispute resolution specialists, contractors, consultants, governments to all come together and network and discuss matters that are related to development of construction law and practice and the avoidance of disputes in the construction industry in Africa. We seek to develop and promote and encourage expertise in the field of construction law through training and capacity building. And this is something that was mentioned at the beginning when Ngo Martins gave his welcome address. If you would like to be a part of this exciting initiative, we would like to encourage you to reach out and join the ACL through the membership portal on the ACL website. As Ngo Martins mentioned earlier on, if you are a dispute resolver, adjudicator, arbitrator, mediator, if you're a lawyer, experts, consultants out there, developers, contractors, whoever you may be, if you're a professional who is involved in any aspect of construction law, if you're an individual who's interested in construction law, please come join us. At present, our members come from all sectors of the construction industry, not just lawyers, not just consultants, but all sectors. So by signing up as a member, you'll be able to keep abreast with the latest events and publications by the ACL. If you have any questions about the ACL itself, please, please, please do not hesitate to contact us on info@africaconstructionlaw.org, or you can contact us through our LinkedIn page. So I'd like to say once more, thank you for joining us today, and we look forward to a time when we'll be able to have these sessions face-to-face and do them in person. Until then, I would like to say thank you and have a good day or have a good evening, as the case may be, and we look forward to seeing you and hosting you again. Thank you.